Ladies and gentlemen, welcome to court, to Broward County Courthouse. This is an open courtroom. There are going to be times when I need to speak to the lawyer's sidebar and when I have to put the white noise on. However, this is still a courtroom. There can't be people walking around talking, laughing. This is a very serious matter that we're here for today, and I need everyone to please remain seated unless, of course, if you need to use the restroom or something to that effect. But otherwise, there should not be any talking. You are more than welcome to step outside into the hallway and talk if you wish, but you should not be doing that in court. As you can imagine, if one person starts talking, then another person starts talking, and then everybody's talking, and we get to a situation where it's just not appropriate courtroom decorum. So everyone, please understand that. Again, it's an open courtroom. You're welcome to be here, but please, everyone, sit quietly and do not use your cell phone unless you are part of the media and you are using it for media purposes. So media, if the staff sees you texting your friend because you're bored, that may affect your press pass. Please only use social media. Only the media with press passes can use electronic devices for the purpose of media business only. All right, at this time, okay. Where's Ann Kammerer? All right, Ann Kammerer is entering the courtroom.
Where is entering? Doors open.
You can have a seat anywhere, Ms. Kammerer. Thank you. Go ahead and have a seat. Okay. Ma'am, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Ms. Kammerer, it was brought to my attention that you may have been at an appointment, a personal appointment, a doctor's office, and that you had some conversation about the case with someone at the doctor's office sometime last week. You may or may not have known that that was not appropriate, or maybe you thought it was, sort of just superficial conversation, but I just need to find out whether or not that's true. I have an affidavit from someone at the office that recalls speaking to you about this case and about your role as a juror in this case. I'm not sure. Have you had any discussion with any doctors, employees, or personnel about your role as a juror in this case?
Well, I was having an appointment that I had to cancel, and so I said that I was on the jury.
Okay. The person whose name is Jessica Cruz says that you were describing the defendant physically and talking specifics about the death penalty and talking about your feelings about the death penalty and asking her feelings about the death penalty. Actually, the person says that this happened some time ago and it was hard for her to remember the exact words, so perhaps it wasn't last week as I said that.
I don't remember describing the defendant or anything to anyone.
Okay, and ma'am, I don't need to embarrass you at all, but I'm just gonna give the affidavit to you and let you read it and see if that's something that happened.
It's just really not true.
Okay, that's why I asked you. And if it's not true, I'm sorry to have embarrassed you or.
I'm sorry that we're going to go through this.
No, that's okay. So this never happened. Is that a no?
Yes, that's a no. I wouldn't have described the defendant or anything like that.
Did you have any conversation at all with this person, Jessica Cruz?
I don't know who she is.
Okay. And so. Did you have any discussion regarding your feelings about the death penalty with anyone? And have you talked about this case with anyone?
Just that I'm a juror.
And you're allowed to say that?
Yeah.
But you haven't had any discussion about feelings about the death penalty or knowing how to process how you feel about the death penalty or anything like that?
No.
And have you had any discussion about what's going on in this courtroom?
No.
Okay. All right. And do you understand my instruction that I gave about not talking about the case?
I
Okay. All right. Thank you very much, ma'am. No, don't apologize. I apologize. I had to bring it to your attention. It was my duty to do so. But if this is not accurate, then it's me who should be apologizing. Okay. Thank you so much.
Thank you.
All right, the juror under oath says that this is not true. So what are you all asking me to do?
Well, the only thing I can say is, Your Honor, is that why would the person say that? I mean,
There could be a lot of reasons. I mean, sometimes people are just mean. I mean, I don't know. I'm not saying this person is, but I'm saying people say things for all different reasons. Because they want their moment of fame, because they want to put their nose where it doesn't belong, or you know, I mean, I don't know. But I certainly can't take the word of someone I've never met over a juror who I've spent hours and hours observing, who just swore under oath that this is absolutely not true.
Judge, we were on an obligation just to bring it forward to the court.
I'm sorry?
We were under an obligation.
Absolutely, absolutely. You know, I don't have a crystal ball, but this juror has never appeared to be anything but forthcoming and honest and answering the attorney's questions and my questions, and she said it didn't happen, so I find her credible.
It's also entirely possible that unless, I mean, I don't know who she spoke to from the state, but that there's a juror with those initials.
There isn't. I went through all
And different ones. Well,
there's AC, but not AK.
I was reminded of one for sure.
Possibly not a seated juror, Judge, but maybe a juror that came through.
It was our decision to, that is the correct juror. It was our decision to just.
Oh, okay, I understand.
Okay, other than that, are we ready to bring in the panel?
take a short 2-minute.
Sure, we're going to take a 2-minute recess. And then for the rest of the day, we're going to follow the schedule. So I have the break.
The person reportedly at a doctor's office regarding the case and her role as a juror, discussing the death penalty. That, of course, is not allowed. The jurors are not allowed to talk to anyone about what they've seen, heard, thought about, not even to their spouse, their best friend, a therapist, no one. They are not allowed to speak to anyone about the case. So what's being alleged here is that that juror did have a conversation with somebody at a doctor's office. That juror was sworn in under oath. She said it never happened. That did not happen. The judge telling the prosecution, what do you want me to do here? I feel that she is credible, that juror is credible, and we should move on with the case. They're taking a 2-minute recess right now. But as you can see on your screen, Nikolas Cruz is in the courtroom. So are the families, victims of that Parkland shooting. They are awaiting a piece of justice. Finally, it's been 4 years and 5 months since that shooting on February 14th, 2018.
Now the jury, it's made up of 12 people, 7 men, 5 women. And here is what we know so far about the jurors. Currently on the main panel are 2 banking executives and 2 technology workers. We have a probation officer, a human resources professional, and a Walmart store stock supervisor. Now we also have a librarian, a medical claims adjuster, a legal assistant, a customs officer, and a retired insurance executive. We also know out of those 12 jurors, at least 5 currently seated are gun owners. Again, 12 jurors make up this panel. We also have 10 alternates that have been selected. The jurors were picked from a final group of 53 candidates by prosecutors and defense attorneys. Those chosen survived 3 rounds of questioning that began on April 4th, and it dragged on through numerous delays caused by illnesses and other factors. These jurors, it is up to them whether or not this Parkland school shooter will either face the death penalty or spend the rest of his life behind bars without parole. This decision, that is what this trial is about. As you know, Nikolas Cruz already pleaded guilty. We're past that. We are now on to the next phase of his destiny. We are now waiting to see what these jurors will decide for what is next for Nikolas Cruz.
And the prosecution has quite a task ahead of them. So does the defense. Prosecution is going to be required to prove beyond a reasonable doubt that Cruz committed at least one aggravating circumstance specified under Florida law. So those include murders that were especially heinous or cruel, committed in a cold and calculated and premeditated manner, or committed during an act that created a great risk of death to many persons. So the prosecution is going to have to prove that. All 12 jurors are going to have to be in agreement, unanimous, for him to get the death penalty in this sentencing phase. Cruz's team can raise several mitigating factors. So the defense can raise several mitigating factors that are also in the law. Before the shooting, Cruz had no criminal history. That's going to be pertinent. The attorneys can argue he was under extreme mental or emotional disturbance, and his capacity to appreciate his conduct's criminality or conform to it to the law was substantially impaired. There's a lot of factors here, a lot of evidence that you're going to hear from the defense in trying to save Nikolas Cruz's life, save him from the death penalty. Cruz's birth mother, for example, abused alcohol and drugs during pregnancy. His attorneys say that that damaged his brain and left him intellectually disabled with behavioral problems starting in as early as preschool. You may also hear evidence from the defense saying a trusted peer sexually abused Nikolas Cruz. When Cruz was 5 years old, his adopted father died of a heart attack in front of him, which left his adoptive mother to raise him and his brother alone. So a lot of factors that each side is going to give to make sure that what they want, the end result, is what they get. So whether it be death or life in prison without parole.
And as Vanessa mentioned, so the defense is focused on explaining and displaying the horror Nikolas Cruz has gone through in his entire lifetime, as you just heard, from preschool to now. The prosecution, on the other hand, they're focusing on the horror the victims' families and the victims have gone through. So as you can imagine, that part alone, that part of the testimony is going to be excruciating. Our legal expert, Howard Finkelstein, has said over and over again that the testimony that we will be hearing during this time is gut-wrenching, and most likely the most gut-wrenching testimony ever heard in an American courtroom.
And we're learning, we want to bring in Howard now, we're learning this is the deadliest U.S. mass shooting to reach a jury, Howard. There really is no precedent in this kind of case.
No, there isn't, and both sides know that. But they also know that they have an awful lot to talk about. The prosecution in this case has 17 people that were murdered and 17 people that were shot and survived, and the stories they tell will be harrowing in their horror. The defense, on the other hand, they have an awful lot to talk about. From the very moment that he was conceived through his short life, there has been one problem after another, one emotional disturbance, one psychiatric disturbance after another. So when you are done listening to all of the testimony from all of the witnesses, it will truly be some of the saddest testimony that you have ever heard. Gut-wrenching when you hear the pain, the horror that was experienced by those that died and those that survived, and the families that go on. And when it comes to the defense, you're going to hear testimony that people are going to say, why didn't somebody do something?
And Howard, we've been saying these jurors are also going to have the opportunity to go through Building 12. So that's something else to keep in mind. It's going to be emotional across the board. Let's listen in. Seems like the judge is speaking once again. Okay, so as you can see, they're still making their way inside, who we assume will be the jurors and the judge. We're going to be listening in just a moment, but as you are taking this live look inside of this Broward County Courthouse, you are seeing the family members of several victims who were killed at Marjory Stoneman Douglas High just over 4 years ago today. This is one of the fathers here. We saw Fred Guttenberg earlier. We have seen several of them. You can hear that someone is speaking. Let's listen in now.
And then when the bailiff announces jurors entering, you can stand back up. We have someone who is busy.
So again, everyone getting situated, the jury walking in, the judge getting situated. Nikolas Cruz has been in that courtroom, as well as the families, these faces, all these people missing their loved one, waiting over 4 years, nearly 4.5 years to get some justice, to finally see the man that took their loved one put to death. Many of the family members have spoken outwardly saying they want the death penalty. They want Cruz to suffer like their children, like their loved ones suffered. So again, this is the sentencing trial. It begins this morning. We're waiting for those opening statements. Cruz pled guilty back in October. So this trial, only one question will be answered. Will he receive life in prison or the death penalty? Again, we are waiting for those opening statements to begin. A panel of 12 jurors walked in, 7 men, 5 women, plus 10 alternates, 9 women and 1 man. They're going to be listening to the testimony from survivors, witnesses, doctors, and experts over the next, what they expect will be months into this trial.
And lengthy days within those next few months. We are expecting the court to be in session on a nearly daily basis from 9 a.m. through 5 p.m. There are some exceptions, a few days in July where the jury will not be present, and then in August it appears there will be no trial on 3 days, or 4 days perhaps. So these will be very lengthy, emotional days for everyone you are seeing right now, for everyone who you don't see right now, who have been fighting for gun legislation, for gun reform, fighting for change. We have heard from multiple students throughout the years asking for change, requesting for change. We have seen different family members doing just the same. So as you take a live look right now, this is inside of the Broward County courtroom, and you can hear the judge speaking. Let's listen in.
It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proves the aggravating factor or factors beyond a reasonable doubt against the defendant in accordance with the law that I provide you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of our fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the lawyers. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the lawyers, the court, that's me, will instruct you on the law applicable to the case. After the final instructions are given, the alternate jurors will be released, and then the jury panel will retire to consider their verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the arguments of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. So even though you are now sworn, you are now a panel, a group of people who are going to essentially be coming here and hearing the testimony and evidence each day, you may not, under any circumstances whatsoever, discuss the case among yourselves until such time as you retire to deliberate. Does everyone understand? Please answer out loud. Yes. Thank you very much. Your verdict must be based solely on the evidence or lack of evidence and the law. I now remind you and instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, no text messaging, no tweeting, blogging, or using any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, you must notify a court personnel of the violation so that they can notify me. So even if it is something small or something that you think may be insignificant, you have a duty to let me know by letting one of the court staff know. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone, and I mean anyone, attempts to say anything to you or in your presence, tell the person that you are on the jury and ask the person to stop. If he or she persists, please leave that person at once and immediately report the matter to one of the court personnel who will advise me. If it's something that occurs on a weekend, you must call my office assistant, and you all have her number, and leave a message and let us know. You have to report it right away. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in court. Turned off means that the phone or other device is actually off and not on silent or vibrate. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to communicate with anyone about the case or the people involved. Do not take any photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. and we will go about, I will instruct you more on your deliberations at a later time. But I will tell you now that we'll give you a contact phone number so that if you have a family emergency or some type of emergency situation, even though you can't be directly reached, you'll be able to be indirectly reached because we'll have a number with somebody standing by to answer the phone in case your loved ones or others call about an emergency, all right? This case must be tried by you only on the evidence presented during trial, in your presence, and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, or any electronic device, or any means at all to get information related to this case or the people and places involved in this case. And this applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any of the places discussed. Jurors must not have a discussion of any sort with friends or family members about the case or the people and places involved. So, do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about the case by using an electronic device. Do not send or accept messages related to the case or your jury service. Do not discuss the case or ask for advice by any means at all, including posting information on a website, internet, chat room, or blog. Now, of course, you are permitted to tell your family members or your employers that you're serving on a jury and that you're not available, and you can even give them our schedule. But you cannot talk about anything substantive or ask for advice or discuss anything other than the fact that you're on a jury and you are not allowed to tell them anything else. The reasons for these rules are because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I will have no way to make sure that the information you obtain is proper for consideration in this case. And the parties, likewise, will have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity that our judicial system promises. Any juror who violates these rules jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over. As you can imagine, this is a tremendous expense and inconvenience, not only to myself and to the lawyers, but to the taxpayers. If you violate these rules, you may face certain sanctions, and I'm not even going to go into those because I know you all are going to follow the rules. Ladies and gentlemen, in every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the existence of the defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that the defendant did not take the witness stand must not influence your verdict in any manner whatsoever. Now, in this case, the defendant has already pled guilty, but you cannot, if he does exercise his right to remain silent, you can't draw any inference whatsoever about his exercise of that right if that in fact happens. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it's made, and likewise, When an objection is sustained or upheld by me, you may not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the lawyers outside of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such conferences may be required or how long they will take. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of the case. Nikolas Cruz, the defendant in this case, has pled guilty to 17 counts of murder in the first degree in a previous proceeding. Your role as the jury in this case will be to determine the appropriate sentence to be imposed. The appropriate sentences for the crime of murder in the first degree is either life in prison without the possibility of parole or death. The attorneys will now have the opportunity, if they wish, to make an opening statement. An opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial, and this is the penalty phase. What the lawyers say during opening statement is not evidence, and you're not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence is presented in order for you to determine, as you will be instructed, 1, whether each aggravating factor is proven beyond a reasonable doubt, 2, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, 3, whether mitigating circumstances are proven by the greater weight of the evidence, 4, whether the aggravating factors outweigh the mitigating circumstances, and 5, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after the argument of counsel, you will be instructed on the law that will guide you during your deliberations. For now, I'm going to explain aggravating factors and mitigating circumstances as I have previously. An aggravating factor is a standard to guide the jury in making the choice between a verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that the aggravating factor exists. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proven beyond a reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, If you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to the mitigating circumstances, you must determine that the aggravating factor or factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factor or factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. If you would like to take notes during trial, you may do so. On the other hand, of course, if you're not required to take notes if you don't want to. That will be left up to each juror individually. You will be provided with a notepad and pen for use, which was on your chair when you sat down. Any notes that you take will be for your personal use and must be taken only on your assigned notepad that was on your chair. However, you may not take the notepads with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver the notes to me and I will destroy them. No one will ever read your notes, including me. We won't read them on the recesses and we won't read them at the end of the trial. They're your notes, they're for your use. And I can promise you that no one else is going to look at them. If you take notes, do not get so involved in the note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Okay, ladies and gentlemen, at this time, both sides are going to have the opportunity to present an opening statement, and pursuant to the rules of procedure, the state goes first. State?
May we have a brief side note?
Okay.
You just heard, once again, these are live pictures inside the courtroom in Fort Lauderdale, the sentencing trial for confessed Parkland school shooter Nikolas Cruz about to begin. You just heard the judge, Circuit Judge Elizabeth Juror, ordering jurors not to talk with anyone about what they have seen, what they're going to hear, any thoughts that they've had. They can't speak to their spouse, best friend, their clergy, therapist, not even each other. So she was just giving those instructions before those opening statements, which is what we're waiting for.
And you see that, I think it was the defense that put the headphones on, and then you heard what appeared to be white noise. We did hear the judge explain something about white noise right before all of this started. We didn't get to hear her explain it all, but perhaps it's headphones of white noise so that they don't hear what the prosecution is asking the judge, since they just asked the judge for a couple of minutes to review some things. Again, this is speculation. It seems like that's what's going on right here. As you take a live look inside of the Broward County courtroom, the judge did say that these opening arguments are going to be starting in just a moment. You can see they are removing their headphones now. Let's listen back in.
Whenever you're ready.
Thank you. Good morning, ladies and gentlemen. I'm going to speak to you about the unspeakable, about this defendant's goal-directed, planned, systematic murder, mass murder of 14 children, an athletic director, a teacher, and a coach. These brutal murders occurred at Marjorie Stoneman Douglas High School in Parkland, Florida, and it happened on February the 14th, 2018. 3 days before these brutal murders, this massacre, the defendant in this case made a cell phone video on his cell phone. And this is what the defendant said. "Hello, my name is Nick. I'm going to be the next school shooter of 2018. My goal is at least 20 people with an AR-15 and some tracer rounds. It's going to be a big event. And when you see me on the news, you'll know who I am. You're all going to die. Ah, yeah, I can't wait. Ah, yeah, I can't wait." Cold, calculated, manipulative, and deadly. Now, Marjorie Stoneman Douglas High School is located at 5901 Pine Island Road in Parkland, Florida. It's bordered by Homburg Road on the north side, the Sawgrass Expressway on the south side, Pine Island Road on the east side, and on the west side is Coral Ridge Drive. But if you, and you'll see a map, before you get to Coral Ridge Drive to the west, there's West Glades Middle School, and then a Walmart, and then there's Coral Ridge Drive. You'll see that Marjorie Stoneman High School kind of resembles a college campus. There was approximately 13 buildings spread out over the campus. Most of the buildings were 1- and 2-story buildings, except for one. The one building that is not a 1- or 2-story building is a 3-story building, and it's known as the 1200 building or the freshman building. The 1200 building is located on the northeast side of the campus. So it's bordered on the north by Homburg Road and Pine Island on the east. It's a 3-story building, and there's 2 entrances to the 1200 building. There's an entrance on the east side, and there's an entrance on the west side. And both those east and west entrances open up to the first floor hallway. The entrances are a double door on the east side and a double door on the west side. And to the right of those double doors, there's a secondary door, both on the east side and on the west side. And this secondary door leads up into the first floor landing of the stairwell. And the stairwells go up to the 3rd floor, both on the east side and on the west side. There are 10 classrooms on each floor of the 1200 building. There's 6 classrooms on the south side of the hall. There's 4 classrooms on the north side of the hall, and that holds true for the 1st floor second floor, and the third floor. And Marjorie Stoneman Douglas, back on February the 14th, 2018, had a surveillance system, and there were approximately 76 cameras that spread out through the campus. And these cameras were motion activated. And what that means is they have to detect motion before they record. So if there's nothing moving, they don't record. In the 1200 building, there were 13 cameras. There were 3 cameras on the first floor, 3 cameras on the second floor, and 3 cameras on the third floor. And these cameras are installed in the ceiling. So there was a camera on the east side in the ceiling, a camera in the center in the ceiling, and a camera on the west in the ceiling, 3 cameras. And there's 3 cameras just like that in the ceilings on the first floor, second floor, and third floor. The camera on the east side, up on the ceiling, focuses west. The camera in the center of the ceiling focuses west. The camera on the west side focuses east. And that's true for the first floor, second floor, and the third floor. And there are 2 additional cameras in each stairwell. There's one on the third floor of the stairwell, one on the second floor of the stairwell. And that's true for the west stairwell and the east stairwell. There are 13 cameras in the 1200 building. There are no cameras in the classrooms. There are no cameras in the classrooms. And again, these cameras are motion activated. So you will see a surveillance video from the Marjorie Stoneman Douglas High School from February the 14th, 2018. You will see the defendant on the first floor fire a rifle, shoot and kill 9 students, the athletic director, and a coach. And the athletic director and the coach were both campus monitors. You will see the defendant fire his rifle 6 times on the second floor. And you will see him shoot and kill 5 students on the third floor and a teacher on the third floor. You will see him wound 13 other students on the first floor, and you'll see him wound 3 other students on the third floor and wounding of a teacher. You will not see every single second of that surveillance video. You're going to say, why? Because it's what? It's motion activated. When the defendant fired his rifle, the percussion in the hallway was so loud that it caused the ceiling tile, the dust from the ceiling tile, to fall down. And when the dust from the ceiling, and it looks like smoke, and when it comes down, it prevented the cameras from detecting some of the motion of the defendant. But most of it is there, and you will see it. The cameras are motion activated. You will also learn that because of the percussion of the defendant firing his rifle, it also affected the fire alarm system. So at 2:20, 2:38, and I'll get back to why that time is important, this fire alarm goes off because the fire alarm system was not able to detect the difference between what? Between smoke and dust. The defendant attended Marjorie Stoneman Douglas High School from August the 15th, 2015 to February the 8th, 2017, and he was also a member of the JROTC. Let me take you back to Valentine's Day, February the 14th, 2018. A Uber stops in front of the east gate to Marjorie Stoneman Douglas High School. It's a pedestrian gate on the east side on Pine Island Road. It's a female Uber driver. The defendant gets out of the seat, the rear seat of the Uber, I think it was a RAV4, and he gets out and he's carrying a black case and a backpack. Now, school's in session. It's Wednesday, February the 14th, 2018. It's approximately 2:19 p.m. The school starts at 7:40 a.m., Marjorie Stoneman Douglas, and the last class ends at 2:40. The gates open in the morning for students to enter and go to class, and then they close. And then they open again, so right before school ends at 2:40, 20 or 30 minutes before. So what? The students can leave the campus. So it's 2:19 p.m. The defendant is carrying a black case and a backpack. And what he has in this case, is a Smith & Wesson 5.56 caliber rifle. And this rifle, basically, it's commonly known as an AR-15. This rifle fires not only 5.56 caliber ammunition, but also fires .223 caliber ammunition. The gun will fire both. This gun is commonly known as an AR-15. It's a semi-automatic rifle. This weapon will fire as many bullets as it contains in the firearm magazine. And this is the way this 5.6 Smith & Wesson M&P 15 TF 16214 is the serial number. This is the way this gun operates. What you do is you load the firearm magazine with bullets. And the bullet is about like this for a 5.56 and a .223. And you put those bullets in the magazine, you load them in the magazine, and the bullets will go in as many as the magazine will hold. So if it's a 40-round magazine, you can stick in 40 bullets. If it's a 30-round magazine, you can stick in 30 bullets. So you fill up the magazine, and then you take the magazine and with how many bullets you have in it, and you stick it into the magazine well of the rifle. And then you pull back the lever, and you charge a bullet that goes into the firing chamber, and you pull the trigger. This weapon will fire as quickly as you can pull the trigger. And that's what the defendant had. And the Uber driver picked up the defendant to bring him to Marjorie Stoneman Douglas High School from 7200 Loxahatchee Road. 72 Loxahatchee Road was the home of Kimberly and James Sneed and their son, J.T. Sneed. J.T. Sneed was a friend of the defendants. They both went to Marjorie Stoneman Douglas High School together. They were both a member of the JROTC together. And a short time after Thanksgiving of 2017, the defendant came to live with the Sneeds. He had his own bedroom. He was attending school. He was working at the Dollar Tree. The Sneeds took the defendant in and offered him a place to live. Why? The defendant's adopted mother passed away November 1st, 2017. The defendant needed a place to live. The Sneeds made the offer. The defendant moved in with them. And it was a short time after Thanksgiving. These murders happened when? February the 14th, 2018. On this particular, and when the defendant arrived at Marjorie Stoneman High School on Wednesday, February the 14th, 2018, he had been planning to be a school shooter long before he moved in with the Sneeds and long before his mother passed away. On this particular Wednesday, on this particular Valentine's Day, the defendant gets out of the Uber. He goes through the passenger gate. He's wearing his backpack. He's carrying his black case. It was a black Cabela bag case with a rifle in it. And he walks about 360 feet from Pine Island Road to the east entrance double doors. He walks in through the east double doors, makes an immediate right-hand turn, and walks into the bottom floor of the stairwell, of the east stairwell. He takes his rifle out of the Cabela bag, black bag, and as he's preparing his rifle to fire, in walks a student, Christopher McKenna. Christopher McKenna was a student in classroom 1216. 1216 is on the first floor. It's the second classroom from the east double door entrances. Christopher McKenna was out on the bathroom pass, and he was going up to the second floor because at the time, the first floor restrooms and the third floor restrooms were locked. And so the security could watch people go to the second floor because they were concerned about, different activities in the first floor and third floor, kids going there vaping or hiding out or whatever. So for a security measure, they did lock the bathroom doors on the first floor and the third floor. So Christopher McKenna gets a pass from his teacher. It was Miss Haas in 1216. She taught English, approximately 30 students in her class. He gets his pass, walks down the hall, bumps into a couple of kids, and you'll see the video of him bumping fists with two of the students, and he walks into the stairwell as the defendant, Nikolas Cruz, is preparing his M&P 15 rifle. And the defendant says to Christopher McKenna, "You better get out of here. Something bad is about to happen." Christopher McKenna runs out. Remember I described the secondary door that's in the stairwell? He runs out that east door, and he runs to find a campus monitor. When he runs out, the defendant enters the first floor hallway. And when he enters the first floor hallway, there are 4 students in the hallway. He gets out, and he fires his weapon at the 4 students in the hallway. The time, 2:21:33. 2:21:33, the massacre begins. Here's who the 4 students were in the first floor hallway. Ashley Baez was walking west in the hallway in front of classroom 1215. And let me describe what existed on the south side. There's 6 classrooms on the south side. So the first classroom on the south side is 1218. The next class, the numbers aren't, consistent, but the next classroom is 1215, classroom 1215. So sitting in front of classroom 1215 is a student, Gina Montalto. And she asked permission from the teacher in 1215. By the way, it was a personalization class, so you can catch up on your homework and do different things, different from when I went to school, but you can do whatever you want in homework, whatever, like a study hall. So she asked Miss Matlock if she could go out in the hall and work on her computer because it was more private and she could get more work done on her project. Miss Matlock had offered her to go to a different classroom or somewhere else. Gina said, "No, fine, I'd like to do that." So she's sitting, and when you watch the video, you'll see her legs sticking out from the front of classroom 1215. Standing next to her, knocking on the door to classroom 1215, was Martin Duque Aquillano and Luke Hoyer. Martin and Luke were coming back from, and you can get permission to go to other classes. They were coming back from somewhere near the administration building. They had to do something. And you'll see them actually coming back down the corridor and walking in. And you'll see him, Luke or Martin, bump fists with Chris McKenna. So they're standing at the door of classroom 1215, and they're knocking to get in, because procedure is when class is in session, the classroom door is supposed to be locked. The defendant fires at Martin Duque Aquillano, Gina Montaldo, and Luke Hoyer. He then turns and goes over to classroom 1216. Remember I described that? That's where Christopher McKenna left from. That's Miss Ha's English class, approximately 24 students in there. He fires into 1216. You'll see on all the doors in the 1200 building, there is a glass window in the metal door. And this window is approximately 8 inches wide and 42 inches long. The defendant fired through that window, shattering the window, and shooting and killing Alex Schachter, who was sitting in his desk. The defendant then turns right outside of classroom 1216. He kneels down, he takes off his backpack, unzips his backpack, and pulls out a black tactical vest. And you'll see the vest. This vest has pouches all over it, so you can stick firearm magazines in it. There were 10 firearm magazines in that black tactical vest. The defendant kneels, takes it out, puts the vest on, takes the expended magazine out of the magazine well of the rifle, and puts in a new magazine. He stands up and he walks over to 1215, where Martin Duque and Luke Hoyer and Gina Montaldo were, and he fires into them. And then he fires into classroom 1214. Remember I said there's 1218, then there's 1215, and then there's 1214. And 1214 and 1215 are adjoining. Their doors are right next to one another. The defendant fires through the glass window and shatters it, and fires into classroom 1214. 1214 is a class that was being taught by Ivy Seamus. She was teaching Holocaust history. He fires in to 1214, and he shoots and kills Helena Ramsey. He shoots and kills Nikolas Cruz, and he wounds Samantha Grady, Samantha Fuentes, Isabel Checker, and Danielle Menescu. He then turns away from 1214 and walks back across the hall to 1216. And he fires again through the shattered window in 1216. This time, he shoots and kills Alyssa Alfadef. He shoots and kills Elena Petty. He wounds Justin Colton. He wounds William Olson. He wounds Genesis Valentin. He wounds Kishaba Magaporian. And he wounds Alexander Dorette, the brother of Nicholas Dorette, who was shot and killed across the hall in 1214. He then turns and walks away from 1216, and he's walking west. At this time, through the west double doors comes running Christopher Hickson. Christopher Hickson was a campus monitor and an athletic director. He comes running through the west doors. The defendant sees him and fires his rifle at Christopher Hickson. Christopher Hickson is hit. He's severely wounded. He falls to the ground, and he crawls over to an alcove on the north side of the first floor hallway. The defendant continues to walk west, and he's walking west. He passes Gina Montaldo, Martin Duque Aquillano, and Luke Hoyer again, and he fires into them again. Then he proceeds west. Now he goes to classroom 1213. 1213 is now the third classroom from the east side. You have 1217, 1216. Remember, he fired into 1216. Now this is 1213. 1213 is a psychology class being taught by Renette Riobin. and the defendant, Nikolas Cruz, does this again. He fires through that window, shatters the glass, shoots and kills 16-year-old Carmen Shentrup. He wounds Madeline Wilford, he wounds Samantha Mayer, and he wounds Benjamin Wickander. He then turns and walks west again. And as he's walking west, he passes Christopher Hickson. And you'll see it. He turns like this and shoots Christopher Hickson again. He continues to walk west, the defendant does, and he reaches the west stairwell door entrance to the stairwell. And he walks into that door, and as he walks in that door, the outside door, remember I said the secondary door, just like on the east side, on the west side, that door opens. And who is it? It's Coach Aaron Feist, who's also a campus monitor. Aaron Feist is the campus monitor that Chris McKenna ran to find to tell him about what he saw. So here's Aaron Feist opening the door. And as the defendant is walking in the first floor stairwell, he turns and he fires his rifle and shoots and kills Aaron Feist. Aaron Feist is shot twice in the chest. He falls right outside the class, that west outside door. The door closes and he falls right outside that door. The defendant then goes up the west stairwell. And as he's going up the west stairwell, there are also, as I said, 10 classrooms on the second floor. Now, the teachers and the students, they heard the shots. And when the fire alarm goes off at 2:22:38, the procedure is to evacuate. No, they didn't evacuate. The defendant fired 70 shots on the first floor and 2 shots in the stairwell. So the teachers and students on the second floor, they heard that. So they didn't follow the procedure of evacuating when there's a fire drill. They fired the procedure that if there's an active shooter, you get away from the door and you turn off the lights and you be quiet. And that's exactly what the students and teachers on the second floor did. So when the defendant gets up on the second floor, he looks in a couple of the classrooms and he fires into classroom 1234 and 1231, shatters the windows. So there was nobody in 1234 or 1231. He he fired 6 shots on the second floor. And he goes to the east side stairwell to go up to the 3rd floor now. Now, the students on the and the teachers on the 3rd floor, they heard some noises, but they weren't distinct like the students and teachers heard on the 2nd floor of the shots being fired. So they didn't hear like gunfire, they didn't hear shots, but they did. They were responding to the fire drill. So the classes empty out. They follow the procedures. Some are going to go down the west stairwell. Some are going to go down the east stairwell. But when the kids are doing that and they're going down the stairwell, then they hear the gunshots on the 2nd floor. So what do? They race back up the east stairwell and the west stairwell, and they run as fast as they can to get back into their classrooms for safety. So when the defendant walks up the east stairwell, there's a teacher helping his students get in to his classroom. His name was Scott Beagle. He was 35 years old, and he was teaching geography in classroom 1256. 1256 is the first classroom from the east side on the north side of the hallway. He has the door open. The kids are going in. The defendant pops out of the east stairwell door and fires into Scott Beagle 4 times, killing him. And he falls right in the entrance to his classroom. And next to Scott Beagle's classroom is 1255 on the north side. And that classroom was an English teacher, Stacy Lapel. And she's hustling all the kids to get into her classroom. And she was successful in doing that But as she's the last one there to close the door, the defendant shoots at her and wounds her. And she closes the door and goes back into her classroom. The defendant continues to fire on the 3rd floor. He's firing from east to west. There are 2 girls, 2 students, Carol Logren and Meadow Pollock. They're in front of classroom 1249 on the south side of the hall. The defendant shoots both of them, and they fall and they go huddle into the alcove of classroom 1249. He fires and hits and wounds Kyle Lehman, Marian Kapichenko, and Anthony Borges. The other students are running away down the hall. They're running from the defendant. He shoots again, and he hits Joaquim Oliver, and Joaquim Oliver ran into the alcove of the men's restroom. Jamie Guttenberg was racing down the hall to get to the stairwell door, and she was shot. Peter Wang, he was doing the same thing. He was running to the stairwell door to run down. He was shot. The defendant then proceeded west again. And as he passes classroom 1249, just as he did on the 1st floor when he went by Gina Montaldo and Martin Duque and Luke Hoyer and Christopher Hickson, he fires into Carol Logren and Meadow Pollock as they were huddled in the alcove of 1249. He then leaves and moves further west. He looks into the alcove of the men's restroom where Joaquim Oliver was wounded. He was shot in the leg. He couldn't run. The defendant fires into and kills Joaquim Oliver. The defendant then turns and walks further down the hall. Jamie Guttenberg was able to reach the door, but she collapsed on the 3rd floor stairwell, and that's where she died. She died on the 3rd floor stairwell of that building. Peter Wang was shot, and he was lying in the southwest corner, right in front of the west stairwell door. The defendant walks up to him and fires into Peter Wang again. Peter Wang was shot 13 times. The defendant then looks out this little window in the stairwell on the west side. He turns and he walks over to room 1240. Now, 1240 is not a classroom. It's a teacher's lounge. And teachers go there, I guess, to papers or whatever they're doing, eat lunch, whatever. There's desks in there, and there's a men's room and a ladies' room in there, restrooms, and a couple other rooms attached once you go into the classroom, the teacher's lounge, 1240. The defendant shoots the glass because 1240 had a glass just like all the other, other rooms, the other classrooms, 8 inches wide, 42 inches long. He shoots through that window and he goes into 1240. Now, when you go into 1240, there's a window on the south side looking over the campus, and there's a window on the west side looking over the campus. And they look over a courtyard, they look over walkways, and they look over parking lots. The defendant fires his rifle at the west window, and you'll see there's 5 bullet holes in the west window, and he fires 5 shots out of the south window. He then leaves 1240. He passes the body of Peter Wang. He opens the west stairwell door. He passes the body of Jamie Guttenberg. He takes off his vest, lays it down on the 3rd floor landing stairwell, takes his rifle, lays it down, and he runs out. The defendant is wearing a maroon JROTC Stoneman Douglas ROTC shirt that students get when they're members of the JROTC. He's wearing black pants, He's wearing a dark blue baseball cap. He's wearing glasses. He runs down the west stairwell. And he runs down and runs out of the door. And he passes Aaron Price. He leaves the 1200 building at 2:27:55. He started his shooting at 2:21:33. He leaves the 1200 building at 2:27:55. He runs west. Then he turns south and runs by the tennis courts. And he runs and blends in with students and teachers who were evacuating the campus. They were evacuating the campus because they heard the fire drill. When the fire alarm goes off, it goes off through the whole campus. So they were leaving. The defendant runs and gets in with the group, and they all go, this whole group of students and teachers, out to Homburg Road to the north. They pass West Glades Middle School. They go out to Homburg Road. Defendant gets to Homburg Road. He goes west. He walks to Walmart, walks through the parking lot, goes into Walmart, goes into the Subway sandwich shop that's actually in Walmart. He orders an icy. He leaves a tip, pays for it, leaves a tip, takes his icy, walks out of the Subway, sits on a bench inside Walmart, drinks his icy, there for a couple minutes, gets up, and he leaves. And he walks over to Coral Ridge Drive, and he walks south on Coral Ridge Drive, and he walks to a McDonald's on Coral Ridge Drive. He arrives at the McDonald's at 3:01 p.m. And as he walks into the McDonald's, there's a student there named John Wilford. John Wilford was a student at Marjory Stoneman Douglas. He's sitting at one of the booths. He is the brother of Madeline Wilford, who was shot in classroom 1213. John had no idea what was going on. He certainly didn't know his sister was shot. He's calling, waiting for his mother to pick him up, as a lot of the students were, because they had evacuated. He's sitting at the booth. The defendant, Nikolas Cruz, walks up to him and sits across from him in the middle of the booth. And when you see the video, they're going to say, hey, they had to know each other. John Wilford didn't know him. And the defendant asked him for a ride. And John Wilford says, I'm not going to give you a ride. My mom's picking me up. She's going to pick me up. We can't give you a ride. So John's mom arrives in the parking lot. John gets up. He leaves McDonald's. The defendant follows him. He goes with him. He says, hey, look, can you give me a ride? He says, look, I told you, I'm not going to give you a ride. I'm going with my mom. So John gets in his mom's vehicle. They leave. The defendant crosses Coral Ridge Drive, and he walks into an area called Wyndham Lakes. It's a development. He's walking in Wyndham Lakes. And about this time, there's an officer who's responding to help other agencies. His name is Michael Leonard. He's a police officer with the Coconut Creek Police Department. And he's looking for a white male wearing a maroon JROTC Marjory Stoneman Douglas collared shirt, polo shirt, and black pants and a dark hat. So he sees Nikolas Cruz walking on Wyndham Lake South. He pulls him over, stops him, the police come, and he's arrested. The defendant is arrested at approximately 3:40 p.m. The location is approximately a mile and an eighth from McDonald's and 2.9 miles approximately from Marjory Stoneman Douglas. The police and the medical examiner's office, after that, arrive at Marjory Stoneman Douglas at the 1200 building. And this is what they find. There are 14 deceased bodies at Marjory Stoneman Douglas at the 1200 building. There are another 2 bodies at the North District Hospital. They were Gina Montaldo, the little girl who was sitting outside with her computer outside 12:15. They took her to the hospital. Gina was shot 4 times. She was 14 years old, and she died from her wounds. They also took Christopher McKenna, because Christopher Hickson, the athletic director, who crawled over to the north side of the wall in that alcove. When the police came, he was still alive. They took him to the North District Hospital. Christopher Hickson, the athletic director, the campus monitor, was 49 years old. He was shot 3 times, and he died of his wounds. Martin Duque Aquillano is 14 years old. He was with Luke Hoyer, knocking on the classroom door of 1215. When the police came, they took him out, and they took him to Homburg Road and Pine Island Road to see if they could help him. Martin Duque Aquillano was 14 years old. He was shot 8 times, and he died of his wounds. And then when the medical examiner and the police came in, they saw Luke Hoyer. He had been moved by the police so students could get out of 1215, but Luke was still in the hallway. Luke was 15 years old. He was shot twice, and he died of his wounds. They went over to classroom 1216. It was Miss Haas' English class. Sure enough, Alex Schachter, 14 years old, was shot twice in the chest, and he died of his wounds. Alyssa Alfadef was 14 years old. She was in classroom 1216. She was shot 8 times, and she died of her wounds. Elena Petty was in classroom 1216. She was shot 4 times, and she died of her wounds. The police and medical examiners then went across the hall to 1214, Ms. Seamus's class, who was teaching Holocaust history. Helena Ramsey was shot 4 times. 17 years old, she died of her wounds. Nicholas Cruz was shot 3 times in 1214, was shot 3 times. He was 17 years old, and he died of his wounds. And they crossed the hall to classroom 1213. In 1213, it was Carmen Chintrum. Carmen Chintrum was 16 years old, and she was shot 3 times, and she died of her wounds. They then saw Aaron Feiss, and Aaron Feiss was still lying just outside the west stairwell door, just to the south of the double doors to the west entrance. Aaron Feiss was shot twice in the chest, and he died of his wounds. The police had brought down, before the medical examiner got there, Jamie Guttenberg from the 3rd floor landing, and she was outside just to the north of the double doors on the west entrance. Jamie was shot 1 time. Jamie was 14 years old, and she died of her wounds. There was no one that was shot and killed on the 2nd floor, but on the 3rd floor, the police found just outside his classroom, 1216, he was moved a little bit too, was Scott Beagle. Scott Beagle was the geography teacher who was holding the door open for the students. Scott Beagle was 35 years old. He was shot 4 times, and he died of his wounds. Further down the hall, right in front of 1249, the police brought the bodies of Meadow Pollock and Carol Logren out to the middle of the hall so students could get out, after this was all over. Meadow Pollock was 18 years old. She was shot 6 times, and she died of her wounds. Carol Logren was 14 years old. She was shot 3 times, and she died of her wounds. They found Joaquim Oliver. Joaquim Oliver was the boy who was shot in the alcove of the men's restroom on the 3rd floor. The police had pulled his body out into the middle of the hallway too. Joaquim was 17 years old. He was shot 4 times, and he died of his wounds. Just to the west, still lying there in the southwest portion of the hall, by the west stairwell door, was Peter Wang. Peter Wang was shot 13 times, and Peter died of his wounds. The BSO crime scene unit came, and they did their investigation. Here's what they found. There were 139 rounds fired in the 1200 building. There were 7 rounds fired on the 1st floor. There were 2 rounds fired in the west stairwell. Remember when the defendant shoots and kills Aaron Price? There were 2 rounds there. 6 rounds were fired on the 2nd floor, and 61 rounds were fired on the 3rd floor. 51 rounds were found, casings were found in the 3rd floor hallway, and 10 rounds were fired in Teacher's Lounge 1240. They found 10 casings in the back part of the bullet. That's why I'm indicating this is what they found. As I said before, when you fire a semi-automatic weapon, a semi-automatic rifle like this one, TF-16214 is the serial number, the casing pops out when another round comes into the chamber for firing, and it falls to the ground. That's how there were 17 casings on the 1st floor, 2 casings in the west stairwell, 6 casings on the 2nd floor, 51 in casings in the 3rd floor hallway, and 10 casings in the teacher's lounge. And of course, there's 5 bullet holes in the west window, and there's 5 bullet holes in the south window. They also found the weapon, the gun, the 5.56 Smith & Wesson M&P 15. It was laying on the stairwell where the defendant left it. Still had a round in the chamber, and it had a magazine in it, and still had 23 rounds in the magazine. And laying next to the gun, just as he left it, was the tactical vest. There were 5 magazines still in the pouches of the tactical vest. There was a 40-round magazine that was fully loaded with 40 rounds. And these 40 rounds, all the rounds were either 5.56 or what, .223, because the defendant's 5.56 M&P 15 fires both 5.56 and .223. So there are 40 rounds in that one 40-round magazine in the tactical vest. There were 4 30-round magazines still in the tactical vest. 3 of those 4 30-round magazines were fully loaded with 30 rounds of either 5.56 or .223 ammunition. And there was the 4th 30-round magazine contained 29 rounds, not 30. They also found magazines that were changed by the defendant, discarded after he was through. On the 1st floor, they found a 10-round empty magazine by his backpack. Remember, knelt, took off his backpack, changed the magazine. It was an empty 10-round magazine by his backpack. In that same hallway, they found an empty 30-round magazine. And all these magazines, by the way, hold both 5.56 ammunition and .223 ammunition. They found this empty 30-round magazine. Then they found another 30-round magazine in the 1st floor hallway that still had 9 rounds in it, live rounds in it. On the 3rd floor, on the hallway, they found an empty 30-round magazine in the hallway itself. And in the teacher's lounge, 1240, they found an empty 40-round magazine, empty. This is what BSO found when they were there. You're going to see that there are 7 aggravating factors applicable to this case. And before I get into that, Judge told you about the aggravating factors and the weighing process. And remember I said it's a weighing process, it's not a counting process. So there are 7 aggravating factors for you to consider. The first one is the defendant has previously been convicted of a capital felony or a felony involving the use or threat of the use of violence. That's one aggravating factor, and I'm going to talk about each one of these aggravating factors in a little bit. The second aggravating factor was the defendant knowingly created great risk of death to many people. That's number two. Number three, that the first-degree murder, or in this case, murders, don't forget there's 17 sentences. So I'm talking about them as there's one, there's 17. That the murders were especially heinous, atrocious, or cruel. 4, that the murders were cold, calculated, and premeditated. That the next one, the murders were done to disrupt or hinder a governmental function, to wit, schooling. The next one is that the victim was an appointed public official in the performance of their duties. Scott Eagle was a teacher. He was an appointed public official. Christopher Hickson was an athletic director and a campus monitor. He was an appointed public official, as was Coach Spice. He was a coach and also a campus monitor. And the last one was that the murders were committed during the course of a burglary. You're saying, burglary? Yeah, burglary. When the defendant entered that school without permission to commit an offense, to wit, murder, that's what a burglary is. And you can see that, let's take previous convictions. So you can, even though they're not prior to February the 14th, 2018, you can consider the murder of 16 other people, even though it's contemporaneous with the one. So if you have the murder of Gina Montaldo, you can use the murders of the other 16 victims as aggravators for that, and it would go for each other murdered victim, okay? And the 17 attempted murder in the first degree of the surviving victims, who I mentioned their names and they were shot, can aggravate each one of the sentences for the deceased murder victims. And the other felony that you can consider, that on November the 13th, 2018, 10 months after the defendant was arrested, the defendant attacked a deputy, violently struggled and fought with him, took his taser, and there's a conviction for attempted battery on a law enforcement officer with a weapon. So they are in that, under that first aggravating factor of previously been convicted. You'll see the evidence will show that there was great risk, obviously, of death to many people. That the murders, all 17, were heinous, atrocious, and cruel. All 17 were cold, calculated, and premeditated. And that to hinder and disrupt the school function. He entered the school, he shoots Scott Beagle and kills him, and Aaron Weiss shoots him and kills him. The athletic director and campus monitor, Christopher Hickson, they were appointed public officials. They were killed, to disrupt and hinder the school function. So they're the aggravating factors that you can consider in this case, and I submit to you have been proven, will be proven beyond a reasonable doubt. And you'll see that these aggravating factors, and listen to, and I know you will, to all the evidence, listen as carefully as you can, and I know you will, that these aggravating factors far outweigh any mitigating circumstances. Anything about the defendant's background, anything about his childhood, anything about his schooling, anything about his mental health, anything about his therapy, anything about his care, that the aggravating factors will outweigh any mitigating circumstances. After this was all over, the police, went back and trying to do as thorough an investigation as they possibly can. They collected the defendant's backpack outside of classroom 1216. They collected this Cabela black case that he had carried his AR type rifle in. It was on the stairwell steps, on the east stairwell. And laying about 3 feet away from the Cabela bag with earbuds still attached to this phone was the defendant's cell phone. 9504-821-1107. And the police did an extraction. And they took all the information from the phone. There were 3 cell phone videos. And the last one, and I'd said it before, the last one was on February the 11th, 2018. Hello, my name is Nick. I'm going to be the next school shooter of 2018. My goal is at least 20 people with an AR and some tracer rounds. I think I can get it done. It's going to be a big event, and when you see me on the news, you'll know who I am. You're all going to die. I can't wait. Those words, those actions of killing 14 children, the athletic director, a coach, and a teacher, is why we're here today. Cold, calculative, manipulative, and deadly.
Thank you, State. At this time, ladies and gentlemen, we're going to take a 10-minute break. Please remember, do not discuss the case, do not begin deliberating, and we'll, again, 10-minute break, and then we'll come back into court and finish our hearing.
We don't have anybody yet. You guys are just ad-lib.
South Florida, if you are just joining us, this is Vanessa Borge and Alex Diarmis in the 7 Newsplex. You are watching live pictures inside the courtroom, the Broward County Courtroom in Fort Lauderdale. The sentencing trial for Nikolas Cruz has begun. The prosecution giving an outline of what their argument will look like for the next few months. We expect this case will go on for at least the next 4 months or so. Michael Satz, the lead prosecutor, described every detail by memory. I'm sure he has a number of notes. He stood in front of that room, in that courtroom, and described every detail of February 14th, 2018 by memory. He knows every detail of this case, every name, every age of every victim. He even knew the serial number of the rifle Cruz used in the shooting. This clearly very personal for him. He began by saying, "I'm going to speak to you about the unspeakable, about this defendant's mass murder of 14 children, an athletic director, a teacher, and a coach." He went on to start talking about that video he just referenced at the end of his opening statements, the video that Nikolas Cruz shot 3 days before the shooting, where he said, quote, "I'm going to be the next school shooter." The prosecution making sure that they made the case that this shooting was cold, calculated, and manipulated. Satz describing the gruesome evidence that jurors are going to be seeing in the next few months during the trial, including videos from several cameras inside the school.
That was tough to listen to. That was very difficult because, as Vanessa mentioned, he went step by step. He explained Nikolas Cruz's every step inside of that 1200 building at Marjory Stoneman Douglas more than 4 years ago. He also went from explaining where all the victims were found to how many rounds were left in Nikolas Cruz's magazine, to how many cases were found when investigators entered. It was difficult, and that's just a preview of what is to come for the next 4 months. As you take a look at the victims' families, you would see them holding hands. You would see them obviously wiping tears. You would see them looking upwards. It is excruciating, but this is something that needs to take place in order to move on. This is a sentencing trial, as we've been mentioning. He already pleaded guilty. This is to decide whether or not Nikolas Cruz will spend the rest of his life behind bars or he will face the death penalty. We saw Jamie Guttenberg there. We saw Alex Shatner's father, Max, who previously, we saw Fred Guttenberg's, Jamie's father, there in the courtroom. We saw Max Shatner, Alex's father, who previously tweeted a montage of photos of him with his son, and also said, I love you, Alex, with the heart emoji. I mean, you cannot even begin to fathom what these family members are going through. But the prosecution, the lead prosecutor, did display everything that these poor students went through that day on Valentine's Day.
And as he was describing it all, even how many shots were fired into their children, which was obviously the most excruciating part of that. We were panning across their faces. You see them right there, because that's what this is about. Justice for these people, justice for their children, their loved ones. We want to bring in our legal analyst, Howard Finkelstein. Howard, Satz made it a point. He emphasized the times Cruz would then turn back around and shoot once again the victims he had already shot. Why is that so important in this case?
The reason that is so important is the law tries to set out kind of degrees of awfulness when it comes to murder. And what the law has determined is if a victim knows that their death is imminent, it's more awful than if they don't know. So if the first shot knocks them down, but they're still conscious, and they see other students being shot, they are in fear. And when the gunman then turns and fires another shot, the law says that's an aggravating factor. The third shot becomes even more, and that's the focal point for what Mr. Satz was talking about when he was talking about heinous, atrocious, and cruel. It's the time between the first shot and the kill shot, the horror that the victim suffered and was emotionally destroyed before their death.
Howard, we also heard the lead prosecutor explain the 7 aggravated factors. Can you emphasize a little bit about this? These are the specific bullet points that he's going to be breaking down for the jury?
Yeah, exactly. The law says that in order for there to be a death sentence, there has to be at least one aggravating factor which the jury finds exists beyond and to the exclusion of every reasonable doubt. In this case, the prosecution has many different aggravators. We've talked about heinous, atrocious, and cruel. We've talked about cold, calculated, and premeditated. Well, there's also additional ones, creating a great risk of harm to others. Well, in this case, while there are 17 separate prosecutions going on, each and every one of them are part and parcel of the aggravating factor to the other one, to the 17th one. And so what Mr. Satz was talking about was all of the various different legal factors that the jury can hang their hat on to say, we believe in this case, it is so awful, it is filled with so much horror that a death sentence is the only appropriate sentence. And legally, when an appellate court looks at it, they will look to determine if the evidence supports a finding that, in fact, the murder was heinous, atrocious, and cruel. And in this case, the prosecution will have an awful lot of evidence as to many different aggravating factors. And while the defense will have many mitigating factors, this will really come down to the individual juror, each individual juror weighing the horror on both sides, but mostly to the victims, and then the awfulness of the defendant's life, and then coming to a decision whether or not Cruz should receive a death sentence or a life sentence, and it only takes one juror for the defense to have their way.
And Howard Satz, during those opening statements, described the attack on a guard while Cruz was in prison. This was after the shooting. How does that play into their case?
Well, it plays in because they're going to try to show it's another aggravating factor, and it also kind of lays the groundwork for the argument that many defense lawyers make that while life in prison may be awful to most of us, he can still have a decent contributing life from prison. Well, the prosecution, by introducing this, says, Oh no, because his behavior continues to still be antisocial. So no, there's no reason to believe that he's going to turn his life around in prison. And what the prosecution is trying to do is say this person is bad through and through and deserves no break of any kind.
Based on your experience, so many years of experience, what was your perspective and opinion on that opening statement from the lead prosecutor?
It was a classic Mike Satz opening statement. For those of you who remember the TV show Dragnet with Sergeant Joe Friday, it would open with, "The facts, ma'am, only the facts." Well, that's what you just saw. Mr. Satz laid out fact by fact how everybody got there, what happened, both during and at that building, and what happened immediately afterwards. He created an outline and a framework so that when witnesses come in and testify over the next few months, each juror is going to be able to know where that witness fits in the greater context of the crime and the prosecution's theory. So he did an excellent job laying out 17 separate prosecutions.
I mean, he knew every single detail, Howard, to the rifle number, to the serial number of the rifle that Cruz used, every single student, the layout of the building. For lack of a better word, it was extremely impressive. He never looked down at his notes. This was very personal to him and those family members in the audience, excruciating to listen to, but vital. Those jurors need to know exactly what happened. And as he's trying to argue how calculated, cold and calculated these murders were. What will happen for the rest of the day? We heard the prosecution, their opening statements. What happens now?
I believe you're going to see the defense get up and give their opening statement. I don't think they're going to delay it till the end of the state's case. Most lawyers understand that if you take that tack, by the time you stand up, you've already lost the case. So I think you're going to see the defense give an opening statement, and they're going to probably do something similar. They're going to lay out a whole bunch of factors that constitute mitigating factors so that the jury will also have an ability when they call their witnesses, which may be several months down the road, the jury will at least understand where that witness fits in the context of all of the other defense witnesses, the defense theory, and the trial. So I think that's where we go next, and then it's going to be all the prosecution, and the question will be, will he begin the prosecution with police witnesses to kind of lay out a timeline, or will he begin with emotionally impactful testimony? And when the witnesses who were in that school, especially the ones that were shot and survived, get on the stand to testify, that will be the most compelling testimony you've probably ever heard in your life.
Howard, during that entire time, we saw Nikolas Cruz, for the most part, looking down. He had his hand on his head. He did pass some notes to the Assistant Public Defender, Mr. David Wheeler. What do you think Mr. Wheeler is doing right now? What is he thinking? What is he preparing? What's your opinion on that?
Okay. Well, it's very common for a defense lawyer to tell their client, look, you don't want to be looking and making faces and fidgeting or showing an inappropriate emotional reaction. And very often what you do is you tell your client, keep looking down at that pad, that yellow pad, and you can write notes about what's happening, you can doodle, you can pass me notes. That was more about keeping Cruz busy and keeping his eyes and face away from the jury so that no reactions on his part offended them than it was Cruz actually contributing to the defense strategy.
Howard, we know the jurors will not be anonymous. In fact, at the beginning, before the opening statement from the prosecution, we heard a discrepancy with a juror that had a conversation with a person allegedly at a doctor's office regarding her role as a juror. The judge deciding that the juror saying, no, that never happened. Judge deciding she was credible. And we actually heard her name as well, the judge saying her name. So we know the jurors will not be anonymous. They're going to be going through months of horrific evidence, as we've mentioned, and they can't talk to anyone about it. This is a tough toll for anyone.
The jury, none of them will be the same after this trial, after their service, that they were before. It will be emotional, it will be taxing physically as well as emotionally, and it will go on for a long period of time. And yes, when you are involved in something that is so intense, the fact that you can't discuss it with anybody makes it really, really difficult. And the fact that it's going to be going on while there is all of this media coverage going on for the next few months makes it even more difficult. I don't think we have seen the last of juror issues. This case is a mammoth case. It is unprecedented, and with unprecedented cases come unprecedented problems.
Howard, the state does not provide any counseling services or anything that will help these jurors after this is over, correct?
That's correct. You know, some states do have psychiatric and psychological counseling services for jurors that have been traumatized. I can tell you that in Florida, we don't have those services and we don't have those laws to provide them to jurors. And in this case, these jurors will be traumatized. Nobody will be able to watch these videos and have it unaffect them. They will be affected in significant and dramatic ways. They will be affected by having to debate and decide whether a human being lives or dies. This experience for each and every one of those jurors will change their life forevermore.
Howard, those videos we keep talking about, the surveillance video, is that something everybody is going to be privy to? Are we all going to be seeing that video, or is that going to be just for the jurors?
Most of those videos are going to be just for the jurors. There are a lot of reasons for it, because these videos will show various students being murdered. And when people are shot with weaponry like involved in this case, it's not like TV where there's a little blood that comes out of a wound. The video will show devastated bodies, destroyed bodies. And the way I understand the procedure, it will be seen by the jury. The media is not going to be allowed to see it, but they will have, I think, a pool reporter allowed to come in, look at it, and then describe what they see to other reporters. Unfortunately, most people think that being shot and dying is like you see on various different TV shows or various movies. It just isn't that way. When you see a human being die in front of your eyes, it is more awful than anything that you can imagine. More awful.
It's truly unbelievable. It really is, and it's heart-wrenching, and that is what we're going to be hearing for the next several months. Howard, we've mentioned that while the prosecution is focused on what we just heard, talking about the victims and what they've been through, the defense is now going to be focused on what Nikolas Cruz has gone through his entire life. Based on your experience, what do you think the defense will bring forward now in a few minutes when they have their opening statement?
Do you need anything?
They're coming to me.
All right, so we will be going to Howard in just a moment. But in the meantime, we can tell you that you are taking a live look inside of the Broward County Courthouse. We just heard from the prosecution, the lead prosecutor, giving his opening statements, explaining step by step what these victims went through. We can only anticipate next the defense going through Nikolas Cruz's history. We've talked about this, what his upbringing was like, the traumas that he's faced through his life. They're going to explain that the system failed Nikolas Cruz time and time again. It's going to be emotional, but from a different angle.
Howard's been talking about those factors that we expect the defense to bring up. They're going to raise a number of several mitigating factors that are also in the law. Before the shooting, Cruz had no criminal history. That's going to be important in their defense. The attorneys can argue he was under extreme mental and emotional disturbance, and his capacity to appreciate his criminality. The conduct's criminality or conform it to the law was substantially impaired. So again, those are all mitigating factors the defense is going to have to prove in order to get what they want want, which is life in prison. They're trying to save the life of Nikolas Cruz. They're likely going to present evidence about Cruz's birth mother, how she abused alcohol and drugs during pregnancy. His attorneys say that damaged his brain and left him intellectually disabled with behavioral problems starting as early as a preschool. A trusted peer sexually abused Nikolas Cruz. Cruz was 5 years old when his adopted father died of a heart attack in front of him, which left his adopted mother to raise him and his brother alone. His adopted mother abused alcohol and died less than 4 months before the shooting. And just a number of factors that the defense is going to bring up. We're going to hear their opening statements in just a few minutes. They're taking that brief 10-15-minute break after you heard the lead prosecutor give the opening statements for the prosecution.
Now, the jurors, this is really in the hands of the juror. What will happen next to Nikolas Cruz? We can tell you that the jurors currently on the main panel consist of 2 banking executives, 2 technology workers, a probation officer, a human resource professional, a Walmart store stock supervisor. It also includes a librarian, a medical claims adjuster, a legal assistant, a customs officer, and a retired insurance executive. 12 people, 7 men, 5 women. There are 10 alternates already there, already chosen. We know that at least 5 of these jurors currently seated are gun owners. This was a very lengthy process and a very difficult process to find these final jurors. We know that the first phase of jury selection, during the first phase, the prospective panelists were simply asked if their employment and life circumstances would allow them to serve the 4 months that this trial is expected to last. That question alone, we know that about 80% were eliminated right then and there. In the second phase, the 300 potential jurors remaining were asked for their opinions on the death penalty and whether they could be fair to Cruz. About 85 were asked about their lives and their work histories. So many questions trying to narrow down the right jurors. And here we have the final 12, those sitting in this panel with those 10 alternates I mentioned. The selection process, by the way, was stopped several times. One time, we know that the sheriff's deputies who guard the courtroom thought some potential jurors were about to attack Cruz and pulled him to safety as they quickly removed the threatening panelists. And then another time, we know that the judge had to dismiss a group of potential jurors because one wore a T-shirt referencing the shooting that supported the victims and survivors. We also know that there were some delays because of medical reasons. We know that the lead defense attorney had COVID, so that also delayed the process. So in other words, we have waited a long time for this day. But imagine the family members. I mean, what we thought was long is eternal for those sitting right there in the courtroom.
And we saw the faces of so many of them. We saw Tony Montalto. He is the father of 14-year-old Gina. She was killed at Parkland. We saw the mother of Scott Beagle, Alex Schachter's father, Max. We saw a number of faces in the crowd shaking their heads, wiping away tears, as we heard the lead prosecutor, Michael Satz, describing the gruesome evidence that the jurors are expected to see in the trial, all that video evidence, the surveillance video, the prosecution saying the rifle's blast was so powerful that it caused dust to fall from the ceiling at some points, halting the motion-activated cameras from recording. So there's going to be some glitches in that video, but it's all there, he said. All the video is going to be there for those jurors to watch and unfortunately just witness the gruesome murder of 17 people on February 14th, 2018. Satz also described the shooting in detail. He mentioned the first 4 students shot by Cruz, including, as I just mentioned, Gina Montalto, her father, sitting in the audience. When they said Gina's name, they panned to his face. He was shaking his head, wiping away tears. Same with Jamie Guttenberg's father. We saw him and his wife wiping away tears as well. In fact, this morning, Fred Guttenberg tweeted a beautiful picture of his daughter, Jamie, 14 years old. She was in dance. It was a beautiful shot of her while she was dancing. He tweeted, after 4 years and 5 months, today begins the penalty phase trial for Jamie's killer. This trial is expected to take months. Jamie, I miss you beyond words.
And as you take a live look inside of the Broward County courtroom, you can probably feel that emotion from looking at the family members when the camera turns to the side there as the lead prosecutor was giving his opening statement. You see them behind the prosecution right there. They're putting on their headphones, and I was able to confirm what I had said earlier, Vanessa. The sidebars are done so that the other side won't hear what I guess the other team is asking the judge, and it seems like they put their headphones right there again. Perhaps the defense is asking the judge something. Once we do have some audio again into the courtroom, we'll bring that to you. But again, you are taking a live look inside of the Broward County courtroom. This is day one of Nikolas Cruz's sentencing phase. This is the first day where we are hearing these opening statements from both sides, the prosecution and the defense, where both sides are going to be explaining why Nikolas Cruz either deserves the death penalty or the life sentence. We are going to continue to be hearing some emotional testimony and even perhaps having those jurors walk through that building at Marjory Stoneman Douglas, which, by the way, is intact.
Yep.
So very emotional, very emotional.
It has been closed off. It has never been cleaned, never demolished. It is the same building, blood stains and all, inside Building 12 at Marjory Stoneman Douglas High School. We're hearing that those 12 jurors, are going to actually go to the building, walk around, walk the footsteps of Nikolas Cruz that day on February 14th, 2018. Again, nearly 4.5 years later. We talk about waiting. These families have been waiting for this day. This is just the beginning of many months. Cruz pleaded guilty in October to 17 counts of murder, 17 counts of attempted murder. And now it's up to a panel of 12 jurors, 7 men, 5 women, to decide just one question. It's only one question remains now. Does he receive life in prison without parole or the death penalty? They're going to be seeing horrific crime scene photos, videos, autopsy details, heart-wrenching accounts of all these lives that were lost. We're hearing also that family members are going to be speaking as well. Those witness impact statements are going to be read aloud. The traumas that he experienced as well. We're going to hear, as we've discussed, the defense is going to talk about what Nikolas Cruz has gone through, his struggles growing up, the traumas he's experienced in his life, and the jurors now have to weigh that out. Howard's been talking about that all morning long, weighing out, okay, well, if he did experience that, does he deserve life in prison, or does he deserve the death penalty? That's the one question that remains in this very, very long nightmare for these families.
Emotional, without a doubt. And just to clarify one thing on the headphones, I keep bringing them up because you keep seeing them. It's actually, the headphones are so that both sides can talk to the judge and each other without it being on the record. So everyone else is hearing that white noise, but what is being asked to the judge is between just them. And perhaps, Vanessa, remember, we're waiting to see if the defense is going to delay their opening statement, right, or if they're going to do it right now. Howard did mention that he believes, based on his experience, and his opinion, that they will continue now with that, with their opening statements. If you are just joining us, everyone, this is day one of Nikolas Cruz's sentencing phase in this trial. We are waiting to see what happens next. We spent, I think, more than an hour listening to the prosecution.
And it was 6 minutes, 6.5 minutes, give or take, of a shooting, but it took an hour for the prosecutor to describe every single detail of it, because it deserves every detail. Every name, every victim needs to be said, and make sure that every single one of those victims is honored.
And it's also important to note, this is the first time in U.S. history that a juror will hear a case like this. In most cases, the shooter in a mass shooting does not make it to this phase, does not make it to a sentencing trial. So there is no example, there's no blueprint to what we can expect next. We are taking you along for every step of this process. You can see everyone just stood up there. Perhaps the jury is now re-entering the courtroom so that we can see exactly what will happen next on day one of Nikolas Cruz's sentencing trial. Let's listen in.
The attorneys are present. The defendant is present. Is the defense ready to proceed?
Your Honor, at this time, the defense would reserve their opening statement until our case in chief.
Okay. Are you all ready to call your first witness, or did you plan to do that after lunch?
After lunch.
Okay. Ladies and gentlemen, we're going to have an early lunch break today. We're going to be in recess. Well, it's not that early. It's 11:52. So we're going to be in recess until 1:15. So the deputies will walk you out. Please remember not to let anyone approach you. Nobody should approach you, but if anyone approaches you and tries to talk to you, please let them know that it's not appropriate and please report it. Please do not begin deliberating or discussing anything that you've heard so far. You all are welcome to obviously socialize together, have lunch together, and you can talk about anything you want as long as it does not have to do with what goes on in here or this case. Other than that, have a nice break. If you would just please be back at 11:15, that gives you about an hour and 20 minutes. The sheriff's office will let you know exactly where they want you to report because they'll assemble you together as a group, and then they will bring you back in. And we will start with the testimony. I said, did I say 11:15? Yes. Sorry. 1:15. 1:15. That's the type of thing you can't say, by the way. So I meant 1:15, not 11:15. Okay? Thank you so much.
We do have Howard if you want.
Okay, you just heard the judge, Elizabeth Juror, saying that they're going to take a recess until 1:15 p.m. We're expecting to hear the opening statements from the defense. They decided to wait, so we're going to hear from the first witnesses from the prosecution. We want to bring in our legal analyst, Howard Finkelstein. Howard, what just occurred right there after that about 15-minute break?
Okay. The defense always has the option of giving their opening statement right after the prosecution or delaying it till their time to present their case. Most defense lawyers will tell you it's a mistake to delay giving your opening because that means that that jury is only going to hear from the prosecution and then hear from the prosecution witnesses. By the time you get up to give your opening argument, which could be 2 or 3 months down the road, that jury could have made up their mind already, and it's very hard to change a mind once it's formulated an opinion. It's a lot easier to persuade someone before they've decided what the answer is. So I was very surprised to see them delay the opening.
All right, and Howard, it was it a surprise? Because we did think that they were going to give their opening statement right now, too, the defense.
Yeah, I thought they were going to give an opening, too. A lot of times a defense lawyer may decide they think that they're holding a card that they don't want to expose now, that it'll be more powerful down the road. Like I said, most defense lawyers will tell you you should give the opening at the end of the prosecutions, if for no other reason than to convince the jury to keep an open mind until all of the evidence is in. This is a risky move. That doesn't mean it's the wrong move. It's just risky. That by the time the defense gets up to give their opening, which could be, like I said, 2, 3, 4 months down the road, the defense had better hope that the jury hasn't already formulated an opinion and that they keep an open mind. It's not the first time I've seen it, but it is not a usual strategy for most defense lawyers.
All right, Howard Finkelstein, live for us. Howard, thank you for your expertise throughout the morning. They're taking a recess until 1:15. We're going to take a quick break.
Prosecution making their case as opening statements get underway in the penalty trial for the confessed Parkland shooter. Good afternoon, South Florida. The families of the victims listening to every gruesome detail that took place on February 14th, 2018.
Many relatives in tears. We have extensive Team 7 coverage from the courthouse to our legal expert, but we're going to begin with 7's Nicole Insalata. Nicole.
Well, you could see during that opening statement, you could see some of the families were wiping away tears or were looking away or were shaking their heads. Even Nikolas Cruz at one point had his head down while he listened to the prosecutor, in this case, Michael Satz, do a painstaking account of where Nikolas Cruz was inside Marjory Stoneman Douglas High School, how he walked through the second and the third floors and the stairwell, and how he shot each of these victims, all of them, multiple times. Here's a little of what he had to say.
I'm going to speak to you about the unspeakable. 3 days before these brutal murder, this massacre, the defendant in this case made a cell phone video on his cell phone. And this is what the defendant said. Hello. My name is Nick. I'm going to be the next school shooter of 2018. When the defendant arrived at Marjory Stoneman High School on Wednesday, February the 14th, 2018, in walks a student, Christopher McKenna, and he walks into the stairwell as the defendant, Nikolas Cruz, is preparing his M&P 15 rifle. And he said, the defendant says to Christopher McKenna, you better get out of here. Something bad is about to happen. The time, 2:21:33. 2:21:33, the massacre begins. The defendant fires at Martin Duque Aquino, Gina Montaldo, and Luke Hoyer, and shooting and killing Alex Schachter, who was sitting in his desk. And he shoots and kills Helena Ramsey. He shoots and kills Nicholas Dorette.
And then he goes through all of the other ones: Scott Beagle, Jamie Guttenberg, Aaron Feist, Christopher Hickson, Meadow Pollock, Peter Wang, Joaquin Oliver, Elena Petty. All of them hit multiple times. A few of them he would actually go back, according to Michael Satz, and hit again. Peter Wang hit 13 times with some of those rounds, and he said 139 rounds in total fired that day. Now, the prosecutor also mentioned the fact that he had this cell phone video, which, according to the prosecution, shows a premeditation. Also, how he went to the Walmart, to the Subway, to the McDonald's, and spent time, buying a drink, making sure he got out of there with other students. Also showing, according to the prosecution, that this was just not something on a whim, that this was something that took some planning, something he could have walked away from and did not, and then continued to try to conceal what he had done by blending in with other students. We do expect, as you mentioned, to hear from now the other side for the defense now. Several weeks from now, they have decided to go ahead and let the state play out everything they have, all of their testimony, all of their evidence, and how effective that will be with a jury. We will just have to wait and see, and we will have more of this later on. But for now, reporting live in Fort Lauderdale, Nicole Insalata, 7 News.
All right, Nicole, and our team coverage this noon continues with 7's Elitza Bizios and the victims' family members, who are also there in court, as you saw. Elitza.
Alex, the next few months, this trial is supposed to last upwards of 4 months. It's going to be absolutely painstaking, not only for families of these loved ones who lost their loved ones, friends, but really an entire community.
The defendant walks up to him and fires.
Families visibly distraught in the courtroom Monday, listening to the agonizing details of the Parkland school mass shooting. As the sentencing trial for confessed killer Nikolas Cruz is now underway. It's been nearly 4.5 years since Cruz, on Valentine's Day, shot and killed 17 students and teachers and injured an additional 17 at Marjorie Stoneman Douglas High School.
There have been days that I don't want to get out of bed. I mean, I have to be honest with you.
One of the parents in the courtroom Monday, Linda Beagle-Schulman, her son Scott was killed. She recently spoke with 7 News.
But for me, the trial finally happening and knowing that down the line there will be a verdict rendered, okay, that part will definitely be closure.
Also speaking with 7 News, Debbie Hickson, her husband, an athletic director and coach, died trying to save students.
Birthdays, holidays, anniversaries, they're extra hard.
Hickson spending Friday at the cemetery.
Every day I ask him to give me strength, but especially Monday.
Strength that will be needed by many as loved ones and survivors relive those horrific moments as 12 jurors decide if Cruz spends the rest of his life in prison or is executed. Well, obviously, these moments here, they will not bring their children, their loved ones back, but the families we have talked to saying today is another step closer to closure for them. Now, when it comes to Cruz, for him to get the death penalty, all jurors have to vote unanimously on that. For now, we're live in Fort Lauderdale. Elitza Bizio, 7 News.
All right, Elitza, and 7 News legal expert once again, Howard Finkelstein, has been watching the trial along with us all morning long.
Howard, I want to go back to the defense. They just chose to save their statements until the end. Why would they do this, in your opinion?
You know, it's an issue that defense lawyers debate, and most defense lawyers believe that if you delay your opening argument until after the prosecution's case is finished, that many times the jury's already decided and made up their mind what they're going to do before you even get up. The strategy behind delaying it is usually if you have some bit of evidence or some witness that you think will surprise the prosecution or be a surprise to the jury, and you kind of want to protect it and put a spotlight on it. That said, most defense lawyers will tell you delaying your opening argument is very risky because you do risk losing the jury before you even started.
And Howard, what was your takeaway from the prosecution's opening statements?
I thought the prosecution's opening statement was a classic Mike Satz opening statement. It was the facts and nothing but the facts. He laid out 17 separate murder prosecutions. He knew the names of all of the victims, all of the witnesses, even the serial numbers on the guns. He told that jury in very clear, basic language what happened in that building and why they should return a sentence of death.
Howard, assuming that the jurors decide on the death penalty, we're talking about possibly decades before that's actually executed, correct?
That is correct. That's one of the very difficult things, especially for victims, because when you have a death sentence, there is a heightened degree of review by the courts. And even though the case skips one of the appellate court levels and goes right to the Florida Supreme Court, it receives a different type of scrutiny, both in the direct appeals and what they call collateral appeals, and then appeals which will then be filed in federal court. Most of these cases take more than 1 decade, some take more than 2 decades, and all along there will be hearings, and the closure that is sought by many victims rarely ever occurs once a sentence of death has been pronounced.
All right, Howard, always value your input. Thank you for that. We're going to turn now to the survivors of the massacre. They continue to call for change to prevent a similar shooting from ever happening again. 7 Samantha Sosa is live in Parkland with a look at their demands. Samantha.
Vanessa, for many, it has been agonizing waiting for this sentencing trial, but many of these students turned activists have found a way to turn their pain into action. February 14th, 2018, students ushered out of school with their hands in the air. Let's go. In the days and weeks after the shooting, some students quickly went from victim to advocate.
I understand what it's like to text my parents, "Goodbye, I might never ever get to see you again. I love you."
From local city halls to the halls of the state legislature, they laid down the brutal reality of what it's like to face a killer and demanded real action.
Those in power have not taken action.
And quickly, their cries for change grew louder, joined by the voices of millions of students around the country and the globe who walked out of schools in solidarity.
We will accept nothing less than comprehensive gun control.
And then they marched on Washington. In a two-day star-studded event, parents and students from around the country, some victims of school shootings themselves, spoke passionately about wanting laws changed so students can be safe in school.
Since the time that I came out here, it has been 6 minutes and 20 seconds.
But it was MSD student X Gonzalez who made the most poignant speech without using words, standing silent in front of the crowd for the same amount of time that Nikolas Cruz shot up their school.
Fight for your lives before it's someone else's job.
The fight for change landed the student organizers on the cover of Time magazine.
We must stand up together as a unified front as Americans and fight for change because no one else will.
And the former Stoneman Douglas students are still fighting for change in gun laws. Many still serve with the March for Our Lives charity, which grows bigger with every school shooting.
You can't keep up anymore. People cannot keep up with the shootings that are happening in this country.
And while they say each school shooting brings back horrendous memories, it also hardens their resolve to change the laws, to get rid of guns, and still have hope that no student has to ever face being killed in the classroom again.
And even 4 years later, this remains a nationwide movement. Just last week, 50,000 people gathered in Washington, D.C. for a March for Our Lives rally. For now, we are live in Parkland. Samantha Sosa, 7 News.
All right, Samantha, and throughout the trial, be sure to follow our TikTok page at WSVN-7 News. Nicole Insalata will provide live updates from inside the courtroom as they happen.
Thank you. All right, you all may be seated. All right, at this time, the state has presented its opening statement. The defense has reserved their opening statement. So, state, you can go ahead and call your first witness.
Thank you, Your Honor. Brittany Sinich.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. You can go ahead and put your hand down. And if you wouldn't mind scooting out. Please state your full name for the record and spell your last name.
Brittany Sinich, spelled S-I-N-I-T-C-H.
Okay. And Ms. Sinich, what do you do for a living?
I'm a teacher.
And okay. And how long have you been a teacher?
I started in 2017.
Okay, 2017.
Mm-hmm.
And where did you start teaching in 2017?
At Marjorie Stoneman Douglas.
Okay. Are you familiar with Marjorie Stoneman Douglas?
Yes, I was a student there.
Okay.
And then I went on to become a teacher there after college.
Okay. And I'd like to call your attention to February the 14th, Wednesday, February the 14th, 2018. Were you working on that date?
Yes.
Okay. So, Marjorie Stoneman Douglas, where do you work? Where were you teaching on Wednesday, February the 14th?
My classroom was on the first floor of the 1200 building in room 1218.
Okay. Let me show you State's Exhibit Mark A for identification. And ask you if you can identify this photograph.
Yes.
Okay. Does that truly and accurately depict what it shows?
Yes.
As an aerial?
Yes.
And does it truly and accurately depict how Marjorie Stoneman Douglas campus looked on February the 14th, 2018?
Yes, it does.
Your Honor, at this time I'd like to offer State's Exhibit A, please.
Is there any objection?
No, ma'am.
State's Exhibit A for identification will be received as State's Exhibit 1.
Okay. People are amazed that I can work this. All right. Ian, everybody can see that now? Okay. Can you see that, Ms. Sinich?
Yes.
Okay. There's a way you can mark. Do you know how to do that?
Mm-hmm.
Okay. All right. So let me clear the screen. So would you mark where the 1200 building is? Okay. And do you know where the east pedestrian gate is?
Yes.
Okay, all right. And that's the way it exists.
Mr. Sachs, just one moment. Are the monitors? It's my understanding there's some type of privacy screens on the monitors, and the jurors are not able to see what you're showing them completely.
They're supposed to. Who's preventing it?
The screens, the privacy screens themselves. I don't know what that is, but raise your hand if you're having difficulty seeing what is being presented, an aerial photograph. So,
How about that?
The defense is not seeing it either.
We can see the exhibit, but I did not see any markings on the exhibit.
is everyone supposed to be able to see that?
Yeah.
Well, it's not working. So,
No, I believe you.
and on my screen, I'm not seeing that either.
Where's the where it says document? Maybe we can excuse it during.
Okay, ladies and gentlemen, this is a brand new courtroom, has brand new technology. I think I've explained that to you a little bit in jury selection. I apologize for the inconvenience, but we're going to have you go back to the jury room while we try to figure out exactly what's going on. But it's definitely important that everyone can see what's being presented. So please step back with the bailiff. Please do not discuss the case. Leave your notepads on your seats, please. Thank you. Mr. Sachs, I don't know anything about the technology. You can ask Ian. You all can go up and see if you want to.
Well, we checked it Friday. Everything was supposed to work.
No, it's working. It's just that they seem to have a hard time seeing the screen. It's working. You see everything.
Oh, I see.
You see when you're sitting down, I guess they.
No, I believe you. So they can't see from an angle, I guess.
Right.
And the defense doesn't have theirs.
We can see it, but what were we supposed to be seeing when she was marking?
She was marking the 1200 building and the east pedestrian gate.
Right, and then how are we supposed to be able to see?
It's supposed to show up on the screens.
So is that like a circle that she drew on it?
Mm-hmm.
Oh, okay, no, we did not see it.
I mean, this is embarrassing. I'm just saying.
It appeared on that big screen up there.
It did?
Yes, sir.
Yeah, well, it's supposed to.
I know.
Yeah.
I just wanted you to know it did work up there.
Yeah.
taking them off.
I have no idea what they are.
I didn't either. I guess court admin ordered that those be put on, and I'm saying take them off.
Your Honor, the defense is now able to see
Okay.
the markings, and I also want to let the court know we have done our best to work out a system that when sensitive materials come up, the screens are going to be shut down in the back, so please bear with us. Hopefully everything will go smooth.
It's fine. Oh, can we bring the jurors back, please? Thank you.
Can we test it?
Thank you, Ian.
Can you check to see that you can see it? Can you see the markings now? Can you see?
You know what, media, we're in recess while this is going on, please. jurors are present, everyone else may be seated. Ladies and gentlemen, thank you very much for your patience. What we have decided for today is to not, in order to not delay this matter anymore, we're going to ask you that if you are in a seat where you can't see, if you wouldn't mind just standing up and moving over or coming to the end to a place where you can see, sort of adjusting yourself so that you can have a clear view of what's being shown. And then we will, once you go home, we will work on fixing this problem. Who was it that was not able to see? Would you raise your hands again so that I can?
It's been rectified since. It's fine now.
Oh, okay, great. All right, thank you so much. Mr. Sachs, whenever you're ready.
Yeah, thank you, Your Honor.
Sure.
Ms. Sinich, I'm sorry. Would you be good enough to circle the 1200 building again for us?
It's not on the screen, right?
When?
Okay. I just need the tool as well, the pen.
You can press one of the color, you know.
It's not on the bottom right now.
Ian? Wait a minute. There you go. How about that?
No.
No?
Mm-mm. Oh, there it is. Do you see that? I don't know if I did that before, but
It's Ian, it's not shown on my screen to erase it either.
Press.
It's not, I mean, I see all the circles, but the things to annotate are not on here. Anyway, I'll suffer through it. Does everybody can see it, what you circled? No?
I need the pen feature.
Is that the big one?
Okay. Okay. That's what keeps loading when you put it back up.
Oh, you gotta press it.
Okay, so let's erase all this and start again. Okay. Were you able to see that?
Yeah.
Okay.
Okay, everybody sees it? Okay, that's the 1200 building, and the smaller circle is what?
The pedestrian gate.
East pedestrian gate. Okay. All right, let me show you now. State's Exhibit H. Let's see if you can identify that in the signage.
Yes.
Okay, does that accurately, truly depict a map area of Marjorie Stoneman Douglas?
Yes.
Okay. Your Honor, I'd like to offer State's Exhibit H.
Is there any objection?
No, ma'am.
State's Exhibit H for identification will be received as State's Exhibit 2.
And State's Exhibit 2, Ms. Sinich? Can you see that?
Yes.
Okay. And the red block that says 12, is that the 1200 building?
Yes.
And to the right of that, is that Pine Island Road?
Yes.
And to the top of that, Homburg Road?
Yes.
Okay. And that's the way the outline of Marjorie Stoneman Douglas was in February the 14th, 2018?
Yes.
Okay. And lastly, let me show you State's Exhibit marked B for identification. And ask you if you can identify this.
Mm-hmm.
Now, this diagram, I know it's not to perfect scale or anything, but does that show about how many classrooms and the numbers of the classrooms the way existed?
Yes.
On February the 14th, 2018?
Yes.
Okay, Your Honor, I'd like to offer State's Exhibit B.
Is there any objection?
No, ma'am.
States B for identification will be received as States Exhibit 3.
Okay, Ms. Sinich. And where was your classroom?
Room 1218.
Okay.
Here.
So there's 6 classrooms on your side of the hall, right? That's the south side, is that right?
Yes.
And 4 classrooms across from you, correct?
Yes.
And that'd be the north side.
Mm-hmm.
Okay. So let's go to the 4th period. Do you remember the 4th period on February the 14th, 2018?
Yes.
Please tell us what you remember happening.
It was 4th period, which for us was the end of the day because we do block schedule. And it was Valentine's Day, so we were writing Valentine's Day cards. We were reading Romeo and Juliet, so they were pretending to write cards to each other as if they were characters. And we were having so much fun until I heard what I described as just the loudest noise you could possibly imagine, going directly into my hallway. And when that happened, everything was just happening very quick in my classroom. A student made sure the door was shut. We shut the lights off. My students went into corners. I had some with me behind my desk. Almost instantly, I called 911 just out of instinct. They couldn't hear me over the sound of the gunshots. It was so incredibly loud. And that was it. We just hid under my desk, we hid in the corners, and we tried to stay as quiet as possible until what I heard was like a walkie-talkie type of sound. And to me, that's what a police sounds like. So I peeked over my desk and I saw them in uniform, and they signaled us to wait until it was time to leave. And that's when they signaled us out, and we made an immediate right out of my building.
Okay. Did any shots come into your classroom?
No.
Was anyone shot in your classroom?
No.
So these loud bang, how many bangs do you think you heard?
It just wouldn't stop. I don't have an absolute correct number or an accurate number that I could count. It just kept going and going and going.
Did all these bangs have the same degree of loudness, or did they dissipate or appear anywhere else in the building?
They were incredibly loud. The ones that were outside of my classroom, it's like you could just feel it within your body, like all throughout your chest. When he was upstairs, you could tell they were faded, but they were just as loud, where you still knew they were gunshots happening throughout the building.
Okay. And how long did you wait before you heard the walkie-talkie and the police said, "Hold on, we'll get you"?
I don't have an accurate remembrance of time. It felt like a long time being there with my students under there. I don't remember what time it was.
Okay. And when you left, how did you leave?
We exited directly right of my classroom, which was there's an entrance exit door there.
The east entrance toward Pine Island? Okay. And you made a 911 call?
I did.
And what time did you make that 911 call?
So when I heard the first gunshot, it was probably seconds or maybe even a minute after, around 2:22.
Okay. And have you heard that 911 call since then?
Mm-hmm. Yeah.
Let me show you State's Exhibit Mark C for identification. And ask you if you can identify this little drive here.
Yeah.
Okay, and you've heard this?
Mm-hmm. Is that a yes? Yes.
Yes. You guys know what this is? 911 call?
Yes.
Yeah, any objection? Okay. When offer State's Exhibit C, please, Ron.
Okay, without objection, State's Exhibit C for identification will be received as State's Exhibit 4.
And I'd like to play it.
Okay?
Hello, we're at Stoneman Douglas High School, and I think there's a shooter.
Hello? You still there? Talk to me, please.
And those were the bangs that you heard in the beginning of the call, right?
Yes.
Okay. Thank you, Ms. Sinich.
Thank you.
Your Honor, I have no further questions.
Any questions?
No, thank you.
No questions?
No, ma'am.
Okay.
Danielle Gilbert, please.
Thank you, Mr. Excused. Good afternoon. You can go ahead and be seated. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can put your hand down. Please state your full name and spell your last name for the record.
Danielle Gilbert, Gilbert.
State you may inquire.
And Ms. Gilbert, good afternoon. What do you do for a living? Or what?
Oh, I'm a student right now. I go to UCI.
Okay, all right. Normally I would start out by asking your age, but you're out of school now, so I don't want to get anywhere near there. So you're in school, right?
Yes.
Where do you go to school?
University of Central Florida in Orlando.
Okay, what year are you in?
I'm going to be a senior this fall.
Okay, I'd like to call your attention to February the 14th, 2018. Do you remember, were you in school then?
Yes.
And where were you in school?
I was at Marjorie Stoneman Douglas High School.
Okay, and on February the 14th, 2018, what year were you in?
I was a junior.
Okay. I'd like to call your attention to that day, that Wednesday. Do you remember your fourth period?
Yes.
Okay. What time does school start then, on that day?
7:40 a.m.
Okay. And the last class ends at what time?
2:40.
Okay. So your fourth period was what?
AP Psychology.
And who was your teacher?
Miss Rayovan.
And what classroom were you in?
1213.
Okay. So during fourth period, would you please tell us what happened?
Yeah. So at the beginning of fourth period, when it just started, we were in the middle of a lecture, as per usual, and we were all seated in our desks listening to Miss Rayovan give her lecture in the front of the classroom. And in the middle of her lecture, we heard the first couple of shots. And from there, we dropped to the ground and started running towards the window. However, our teacher realized that by the window was right in view of where the window was in the door. And so she had realized that and told us to come behind her desk where we were out of sight of the window.
What kind of window was that?
It was a small rectangular window in the door.
Okay. And so what do you do?
And so once she tells us to go ahead over to her side of the desk where we're out of sight, we immediately turn around and all 31, 32 of us go over to that side of the classroom.
Okay. And then what time does class start, the fourth period? 90-minute class?
It's an hour and a half class.
Hour and a half, so like 1:10?
Sounds about right. I don't remember exactly.
Okay. But you know it ends at 2:40?
Yes.
Okay. So tell us what happens after you go near Miss Rioven's desk.
So then we go over to the other side of the classroom by her desk. And at this time, he still hadn't shot into our classroom at that point. We were just sitting, kind of like sitting ducks. We had no way to protect ourselves, no way to stand up for ourselves. And once we were all kind of over by the door and away from the door, that's when he had shot into our classroom. He injured 4 people in my classroom, one of them being fatal. And from there, we just kind of sat and waited until the police came and took us out of the classroom.
Okay. And who did you see that was injured?
Benjamin Wikander, Samantha Mayer, Madeline Wilford, and Carmen Shenchup had passed away.
Okay. And were you near any of them?
Not in particular. They were more towards the podium and by the whiteboard, and I was more towards the door.
Okay. And did you do anything to record what was occurring?
Yes. I'm not exactly sure why, but my initial instinct was to pick up my phone and start recording. And so I did. I took several videos of what was happening. Yeah.
Okay. And did you retain those recordings?
Yes.
And did you turn them over to the authorities?
Yes.
Okay. And have you viewed those videotapes since?
Yes.
Okay. Let me show you State's Exhibit Mark D for identification and ask you to take a look at this drive, Ms. Gilbert, and see if you can identify her.
Yeah.
And are your 7 videos contained on there?
Yes, they are.
And did you initial this to
I did.
say it was the same, one and the same?
Yes.
Your Honor, this time I'd like to offer State's Exhibit D.
Is there any objection?
Yes, Judge, we have a second.
Sure. will be received as states D for identification will be received as states 4.
Your Honor, and the last...
5, excuse me. Thank you. It's 5.
The last, thank you. The last is sensitive. The last video.
We have the sensitive
Okay.
police.
Oh, perfect. Okay, great.
Over here. Okay?
Nice. Okay.
Thank you.
Okay.
I said 5. I said 4, and then I corrected myself. It's states 5.
Window. What is going on? No. Fireworks don't shatter glass. Lock it. Can you hold, please? What the fuck? Oh my god, that was so exciting. Who is that? I think those police are here. We hear voices. I think so. It sounds like police. No, I don't know. These are police. These are police. We're okay now. Is he gonna get us out? Yeah, like shh. This can't be real. There's just glass everywhere.
Hey. Hey.
These are police.
Hey.
My phone's over there. It was on my desk.
Hey.
They're coming. They're coming. We're okay. My shoes are over there. There's glasses. They got him. Oh my God. Are you recording this?
Hey.
All right, guys. 3 down. 3 injured.
Is anybody injured?
Anybody shot?
Where?
Come here.
You come up. Can you walk? Where were you shot? I need help. I need help. Somebody help me. We got. You guys are okay. We're gonna get you out of here. We're gonna get you out of here. I need your help. You need my help, boss? Yeah.
Logan, my desk is my water bottle. Can you get my phone? With the bag, with the water bottle next to the balloon. Yes.
Let's go. Come on. Let's go. Let's go. Come on. Follow me. Follow me. Follow me. Okay, please.
Hug the wall. Hug the wall.
Go.
Oh my God.
Over the street. All right, come on.
Okay, Ms. Gilbert, I want to show you State's Exhibit marked 3 that's been introduced into evidence. And if you'd be good enough to point out classroom 1213 for us. And do you have the, let me see, yeah, okay. Could you circle 1213? Thank you, okay. Ms. Gilbert, thank you very much. I have no further questions, Your Honor.
Advance any questions?
No, thank you.
Okay, thank you, Miss. You're excused.
I'm getting it.
State when you're ready. Call your next witness.
Dylan Kramer.
You said Dylan Kramer.
Dylan Kramer. Kraemer.
Good afternoon, Mr. Kramer. We don't get called Mr. very often because you're young, but that's what we do in court. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you, sir. You can put your hand down, and please state your full name and spell your last name for the record.
Dylan Henry Kramer, Kraemer.
Okay, Mr. Sachs, you may
Thank you, Your
begin.
Honor. And Mr. Kramer, do you go to school?
Yes, sir.
And where do you go to school?
University of Southern Florida in Tampa.
Okay, could you lean forward so that the microphone can pick you up, okay? Thank you, sir. What year are you in?
I'm a junior.
And what course are you pursuing?
I am a studio art major.
Okay. I'd like to call your attention to
Mr.
when...
Sachs, 1 second. I don't think they can hear him. Can you turn the microphone up? I'm sorry? Can we move it closer to him?
This one?
Okay, if you would just lean in a little bit, please. Thank you.
Okay. So, where did you go to school on Wednesday, February the 14th, 2018?
Marjorie Stoneman Douglas.
Okay. And what year were you in?
A junior.
Okay. I'd like to call your attention to the fourth period that day. Dylan, do you remember what class you had?
Yes, sir. It was room 1214, Ms. Seamus's History of the Holocaust.
Okay. And please tell us what you remember happening during fourth period.
We were in the hallway, we were in the classroom. We finished up with our work. Out of nowhere, we heard a very, very loud sound, assumably gunshots. We all ran to the corner of the room. Some went to the room next to the door. The other half of the class went to diagonal of the window. And we knocked down a file cabinet, tried to get behind it, get as many students behind it, and kind of just waited. And then I peered around the corner, and eventually the shooter started shooting through the window, and bullets were flying through. Ducking down, waiting 20, 30 seconds, and then it stopped, kept going on. And then I looked over, and 2 people were dead, and multiple people were shot.
Okay. And you said the bullets came through the window. Describe where this window was.
The window was in the door into the classroom, right in the middle.
Okay. And did you see anything through the window?
Yes, sir.
What did you see?
I saw the shooter.
What did he look like?
Wearing a hat, glasses, a vest, and I could see his gun.
And did you see the gun?
Yes, sir.
What did the gun look like?
A large AR-15.
Okay. So you said that 2 students were dead. Who were they?
Nicholas Darrett and Helena Ramsey.
Okay. And did you see anyone who else was wounded?
Yes.
Who was wounded?
Sam Grady, Sam Fuentes, Isabel Checker. I can't remember. Multiple people.
Okay. So tell us what happened after that.
We waited. I called the police. I called my parents, or texted my parents. I checked Nick's pulse, and I waited for the police to show up. Eventually they came through, cleared us out, took out the wounded first, and then basically just told us to run out of the building.
I'm sorry.
Out of the building.
And approximately how long did you wait before the police arrived?
Maybe 15 to 20 minutes.
Okay. And did there come a time where you viewed a video of what occurred?
Yes, sir.
And what did it show?
It showed a student in my classroom and the door where the shots were coming through, and you could hear the shots.
Okay. And did that video, that audio video, did it accurately and truly depict what you saw and what you heard?
Yes, sir.
On February the 14th, 2018? I want to show you State's Exhibit Mark E for identification of Mr. Kramer, and ask you if you could look at this drive for me.
Yes, sir.
And have you seen this before?
I have.
And did you watch what was on this video, this audio video?
Mm-hmm.
Did it accurately depict what you heard and saw on February the 14th, 2018?
Definitely.
Okay. Your Honor, I'd like to offer State's Exhibit E.
Mr. Wheeler, are you handling this witness? Defense?
Judge Sam objections again.
Okay. Over the defense objection, State's Exhibit E for identification will be received as State's Exhibit 6.
May I play it, Your Honor?
Yes, the sheriff's office who was blocking some of the view has moved. Do you need them back?
I don't think so. No. I don't
Okay.
think so.
Holy
Can you see the diagram in front of you? It states exhibit Mark 3. Can you see it?
No, sir.
Would you please circle classroom 1214 where
I
you
can't
work?
see it.
What?
Women on sidewalk.
All right. Can you see it? Do you know how to do it?
Probably. Should 1214?
That's it. Okay. All right. Thank you, Mr. Kramer. Your Honor, I have no further questions. Thank you, Mr. Kramer.
Defense, any questions?
No, Your Honor, thank you.
Okay, ladies and gentlemen, thank you very much. We're going to take a 15-minute recess at this time. Please do not discuss the case among yourselves, and we'll be back with you shortly.
client, the defense is moving for a mistrial. During the testimony of Dylan Kramer, he was shown 2 Snapchat videos that were admitted into evidence over the objection of the defense. The objections of the defense were that they were cumulative and that they were inflammatory. Mr. Wheeler adopted the same argument that he made during the state admission of Exhibit 5. These were videos, 2 Snapchat videos that were taken by Matthew Walker inside of the classroom of 1214. During the testimony of Mr. Kramer, he indicated and provided eyewitness testimony as to what he had seen and what he had heard, indicating a description of the firearm that he believed that he saw, as well as the individuals that he witnessed being murdered. When the Snapchat videos were published to the jury at the highest volume possible, and it was also displayed to the gallery.
Let's not say things like that unless you don't approve that.
I do believe that the state admitted, he said he had it at the highest volume possible and then he had to reduce it. The video was also displayed to the gallery. It was during that time that one member of the victim's family or friend made an audible response saying, "Turn it off, turn it off." It was at that time that the court turned on the white noise. The Broward Sheriff's Office followed the instructions that the court had previously given them, which was that any individual who is disruptive or has an emotional outcry should be removed by the Broward Sheriff's Office. Judge, it is necessary to declare a mistrial in this case because the jury was present during all of this. It would bring unfair prejudice to Mr. Cruz, impairs fair trial rights. It could inflame the jury, garner additional sympathy and anger towards the client. A denial of this motion would violate Mr. Cruz's right to due process guaranteed by the 15th and 14th Amendment of the United States Constitution, as well as Article 1, Section 9 of the Florida Constitution, and 6th and 14th Amendments of the United States Constitution, Article 1, Section 16 and 22 of the Florida Constitution, as well as the 9th and 14th Amendments of the United States Constitution, equal protection and basic rights guaranteed by the 14th Amendment of the United States Constitution. Based on the foregoing reasons, the defense moves for a mistrial as the prejudice to Mr. Cruz by what happened in this courtroom in front of the jury would render this court to provide Mr. Cruz with the ability to have a fair and impartial trial. This is upon consultation with our client, and he is in agreement.
Okay, first of all, my desk is elevated, and I could not see who was speaking because the person is in at least the 6th or 7th row, which I would say is at least 150 feet from the bench. That's number one. Number two, I couldn't hear what the person said. In the abundance of caution, I asked the white noise be put on. But somebody shouting one thing when you don't see them or you can't hear exactly what they're saying is not even close to grounds for a mistrial. The jurors, I don't even think any of them looked. As far as the volume being on the loudest volume possible, that's not grounds for a mistrial. I asked the state next time turn it down a little bit, but so that people can see it. But your motion's denied.
I understand the court's ruling, but as an officer of the court, I can make a representation that I heard the individual in the gallery of this courtroom say twice, "Turn it off, turn it off."
Do you want to say anything on state? I advised the lawyers what the witness said because the sheriff's office told me.
Your Honor.
And that's the only reason that I knew. The defense did not tell me what the witness said until just now, as an officer of the court or not.
Your Honor, the state agrees with the court's ruling, and the volume was very loud. It was extremely loud, and I think that the witness, or not the witness, turn it off, turn it off. The volume was so loud as to turn the volume down, Your Honor. That's what it could be attributed to. And we agree with the court's ruling. The motion for mistrial should be denied.
All right, State, do you have another witness to call?
Yeah.
Okay, go ahead.
Jury's not here.
Oh, can you bring it up, please? Thank you for reminding me. Small oversight. Thank you for your patience. The jurors are present. State, call your next witness.
Thank you, Your Honor. Maximo Rosario.
Good afternoon, sir. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can put your hand down and be seated. And when you're seated, please state your full name and spell your last name for the record.
My name is Maximo A. Rosario. Last name is Rosario.
And Mr. Rosario, what do you do for a living?
I currently work for the Broward County School Board.
And what do you do for the Broward County School Board?
I'm the current director of classroom technology.
Okay. And how long have you had that position?
4 years.
Are you familiar with Marjorie Stoneman Douglas High School?
I am.
And how are you familiar with it?
I was assistant principal there for 10 years.
How long were you an assistant principal?
10 years,
10 years?
over 10 years.
Okay. When did you start as an assistant principal?
I was appointed in December of 2007.
Okay. Did you have anything to do with the video surveillance system that was set up at Marjorie Stoneman Douglas?
I did.
Please tell us what part you played in it.
So I've done the training, and I was trained by district staff on how to use a system that was installed at Marjorie Stoneman Douglas.
Okay. And when did that take place, sir?
So there was a system already in place. So it was upgraded as time progressed and new buildings were constructed.
Okay. So in February of 2018, were you familiar with how the system operated?
Yes.
And how did it operate?
Basically, a recorded motion sensor activated and recorded 24 hours a day, 7 days a week.
Okay. And was there a server that controlled everything?
Yes.
And where was the server located?
The main server was located at the media center in the back room, locked behind a cage.
Okay. And how is the server secured?
So it was a room in the back of the media center. Only certain staff had access to that particular room. Inside that room, there was a locked cage with a padlock. And only myself and the microtech had access to that particular lock cage.
Okay. So it was secure?
Yes, sir.
So, and that's the way it existed on February the 14th, 2018?
Yes, sir.
Okay. How does the system, you said the system is motion activated. How does that work?
Basically, when activity happens in front of a particular camera that was distributed around the school, the video surveillance system will start recording that particular activity, whatever it may be.
Okay. And if there's no movement, it doesn't record?
It does not.
Okay. Have you ever done downloads from the server?
I have, yes.
And how do you do that?
Basically, we have a local computer where you can then export from the server into a local hard drive and then transport it to either at that time a CD or a flash drive.
Okay. And have you done that prior to February the 14th, 2018? Had you done that many times?
Yes.
Had it always been proven to be accurate?
Yes, sir.
Time, date?
Correct.
The cameras in the 1200 building, you familiar with the cameras in the 1200 building?
I am.
Were you instrumental in upgrading those cameras?
So they were the newest cameras in the building when they were installed. Our building was constructed in 2009, and they have put in the higher resolution cameras in that particular building.
Okay. Let me show you now State's Exhibits J and I. I've shown these to the judge, Your Honor.
Okay.
J and I for identification. Let me just show you first I, Mr. Rosario, if you don't mind taking a look at that. Do you recognize what that depicts?
Yes.
Does that accurately and truly depict the east entrance to the 1200 building as it existed on February the 14th, 2018?
It does.
Okay. And I show you State's Exhibit J and ask you, does this photograph, State's Exhibit J, truly and accurately depict the west side doors that existed on February 14, 2008?
It does.
Thank you. Your Honor, I'd like to offer I and J.
Is there any objection?
Oh, ma'am.
Okay, States I for identification will be received as States 7, and States J for identification will be received as States 8.
I want to show you first, Mr. Rosero, State's Exhibit 7. Can you see that on your screen?
I can.
And what does this depict?
That is the east side of the 1200 building.
Okay. And there's 2 double doors I see there, right?
Correct.
Where do they lead to?
Those lead straight into the corridor where the classrooms are.
Okay. On the first floor, obviously.
That's correct.
Okay.
Yes.
And how about the door to my right of it?
So that door goes right into the staircase.
Okay. And I'll show you State's Exhibit number 8. And can you tell us what that depicts?
Yes, that's the west side of the 1200 building, front entrance, first floor.
Okay, and those double doors, where do they lead to?
They lead to the main hallway where the classrooms are opposite of the other.
Okay, on the first floor, obviously.
On the first floor, yes.
And how about the door to the right of
The
that?
door to the right leads straight into the staircase.
Okay. Now I want to show you State's Exhibits K, L, and M. Mr. Rosero, if you'd be good enough to take a look at these exhibits.
Okay, this one is the west side of the front entrance that you just showed me. That's the inside part of the corridor.
That's K.
This is the center of the hallway as you come into the first floor.
Okay, and that's L.
And this is the interior side of the east door side of the 1200 building.
And they accurately depict the east, central, and west entrance, the east and west entrances in the central part of the first floor hallway?
They do.
And then you depict where the cameras are?
I can, yes.
Do they depict where the east, central, and...
Yes, so the first camera is right over the double doors, as
Okay.
you mentioned. The camera in the center aisle is right over the bathroom doors, past the exit sign, past the smoke alarm or detector that's there. The camera, you can see it facing the east. And then on the east end, you can see the camera right over the door again, facing in.
All right. Your Honor, I'd like to offer State's Exhibits K, L, and M.
Is there any objection?
No, no.
Okay, States K for identification will be received as States 9. States L for identification will be received as States 10. And States M, as in Mary, for identification will be received as States 11.
Thank you, ma'am. Okay, Mr. Rosero, now I want to show you State's Exhibit marked 11 that you have identified as, I think you said it's the east entrance door, the interior?
That's correct.
Okay. All right. Is that what that is?
Yes, sir.
All right, could you, do you know how to use, I say do you know how to use because I don't. Do you know how to use the, where you can circle it with, that's it, okay. What is that?
That is the camera pointing
Okay.
west in the first floor.
And it's facing west?
Yes, sir.
Focusing west, okay. And that's State's Exhibit 11. I'm going to show you State's Exhibit 10.
So that is the center view, and the camera is located. Oh, you moved it.
Oh, I'm sorry. Oh.
Okay, so camera's right there.
Okay.
The bathroom.
All right.
Facing east.
Okay. And showing you west or east?
Looks like it's facing east.
Okay. And here's State's Exhibit 9.
Okay, this is the west side of the building. The camera is located right there.
Okay. So all the three cameras that you identified, east, west, and central, is that the way it is for all three floors?
Yes, sir.
Okay. And showing you State's Exhibits N and O. And I ask you, Mr. Rosario, if you can identify those.
So these are staircases. I couldn't tell you which one is east or west, but these are the first landing and the second landing. They were both identical, both on the east and the west side of the staircases.
And they show where the cameras are?
They do.
Okay. And does it accurately depict where the cameras were, whether it's east stairwell or west stairwell as it existed on February the 14th, 2000?
It does, yes.
Your Honor, I'd like to offer State's Exhibits O and N.
Is there any objection? Did you say no?
No, Judge.
Okay, thank you. States N, as in Nancy, for identification will be received as states 12, and states O for identification will be received as states 13.
Mr. Rosario, I'm now showing you State's Exhibit 13. Can you see that okay?
I can.
Okay, and would you point out for the camera for us?
Camera's located right there.
Okay. And State's Exhibit 12.
Camera located
Right there, okay. And that's the way the cameras were on both the east and the west stairwells, correct? Okay. How many people do you feel you trained on the surveillance system when you were the assistant principal at Marjorie Stoneman Douglas?
Roughly maybe 20, 25 different people.
Okay. Okay, thank you, Your Honor. Have no further questions of Mr. Rosario.
Thank you. Defense, any questions?
No, Judge, thank you.
Thank you, sir. You're excused. State, call your next witness.
Edward Kessler. Appreciate it.
Good afternoon, sir. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sir. You can put your hand down and be seated. And when you're seated, please state your full name and spell your last name for the record.
James Edward Kessler, Kessler.
State your name prior.
Thank you, Your Honor. And your occupation, sir?
I'm a systems analyst with the School Board of Broward County.
And what is your training and experience?
My background is managing the video surveillance systems at the sites.
Okay. And are you familiar with the surveillance system that exists? First of all, how long have you been doing that?
I've been in that capacity approximately 5.5 years.
Okay. And what are you doing now?
Same.
Same thing? Were you familiar with the surveillance system that existed in Marjorie Stoneman Douglas High School on February the 14th, 2018?
Yes.
And how did the system operate?
It's a computer-based system. There's a large server which sits on campus, which contains all the video recordings. The cameras connect to the computer network, same as phones and computers and other things. And the cameras and the server communicate, and once they sync up, anything that the camera sees is automatically sent to and stored on the server.
Okay. And how does the system work? As far as, is it motion activated?
Yes.
Yeah. Okay.
So the system is typically set up to record on motion, so that we're not recording empty hallways in the middle of the night or on weekends when nobody's around.
Okay. I'd like to call your attention to February the 16th, 2018. Were you working that day?
Yes, I was.
And did you have occasion to go to Marjory Stoneman Douglas High School?
Yes, I did.
Okay. And when you were there, did you have an occasion to meet with the FBI?
Yes, I did.
And did you go to the server room?
Yes.
Do you remember where the server room was?
Yes.
Where was it?
Second floor, back of the media center.
Okay. And do you remember how it was secured?
Yes. So there's a large room that has a chain link fence cage within it, and the server and the network equipment was in that chain link room.
Okay. I'd like to show you I want to show you State's Exhibit marked P for identification, Mr. Kessler. Can you identify that?
This is a property pass that I and the FBI signed when they took possession of the server.
Okay. And tell us how that transaction occurred.
We received a subpoena, a warrant.
No. How did it physically go?
We did a normal shutdown on the server, like you would any other computer. Disconnected all the cables from it, pulled it out of the rack in which it was installed in, and physically put it on a table and handed it to the FBI.
Okay. And that's a property receipt for the server?
Yes.
Okay. And let me show you. And the server had a serial number?
Correct.
And what is the serial number?
JFK 80M2.
Okay. And showing you State's. State's Exhibits Q, S, and R, and ask you if you can identify those photographs.
These are pictures of the actual server that was removed from the site.
And given to the FBI?
Correct.
Okay.
The serial number matches the property pass.
Okay. Thank you very much, Mr. Kessler. Your Honor, at this time, I'd like to offer State's Exhibit P, property receipt, and State's Exhibits Q, R, and S, the photographs of the server.
Mr. Wheeler, is there any objection?
No objection, Judge.
Okay, States P will be received as States 14. States Q for identification will be received as States 15. States R for identification will be received as States 16. And States S for identification will be received as States 17.
Thank you, Your Honor. I have no further questions of Mr. Kessler. Thank you, Mr. Kessler.
Okay, Mr. Wheeler, any questions?
No, Judge.
Okay, thank you, sir.
Thank you.
You're excused. State when you're ready. Call your next witness, please.
Okay. Carlos Castillo.
Good afternoon, sir. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you, sir. You can put your hand down and be seated. When you're seated, please state your full name and spell your last name for the record.
Carlos M. Costello. Costello is Castello.
And what's your occupation?
I am retired.
I know. When did you retire?
I retired at the end of 2019. Prior to that, I was employed as a special agent with the Federal Bureau of Investigation.
Okay. And how long had you been a special agent with the FBI?
Approximately 31 and a half years.
Okay. I'd like to call your attention to February the 16th, 2018, do you remember that date?
Yes, I do.
And did you have an occasion to respond to a certain location?
I did.
And where did you respond to?
I responded to the Marjorie Stoneman Douglas High School in Parkland.
Okay. And did you obtain anything when you went to Marjorie Stoneman Douglas High School?
I was sent there to take custody of the video server at the school.
Okay. And I'd like to show you State's Exhibit Mark 14 that has been identified as a property receipt for a server. Do you recognize that?
Yes, sir. This is the property receipt I filled out for receipt of the school video server.
Okay. And did you sign it?
And that, yes, sir. That's my name, my signature on there.
And has a serial number?
It does have the serial number for the server, yes.
Okay. And now I show you State's Exhibits Marks 15, 16, and 17 that have been identified as the server. Do you recognize those photographs?
All right, this first photograph shows the 1B1 item number, which is the item number for the server. JFK80M2 is the serial number for the server. That's the second photograph. And then the last photograph is sort of the back of the server. It shows it's a PowerEdge R530 server, which is consistent with the server that was seized.
Okay. So the FBI took custody of the server.
That's correct.
And where did you all take it to?
It was eventually taken over to the federal building over in Miramar, Florida.
And
the
who?
FBI
I'm
building.
sorry.
Yes. No, I'm sorry. Go ahead.
No, I interrupted you.
No, we took the server was taken by one of the other examiners to the FBI building in Miramar, Florida.
And who was that?
That was Gaston Nieves.
Okay. And he was with you when you collected the server, correct?
That's correct. Yes.
Okay. Thank you, Mr. Castillo. Appreciate it. No further questions, Your Honor.
No questions.
Thank you, sir. You're excused.
Thank you. Thank you.
I have another witness, Your Honor. Okay. Yes, go on, Rebates. No.
Sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you, sir. You can put your hand down and be seated. And when you're seated, please state your full name and spell your last name for the record.
Gaston Nieves, Nieves.
Can you inquire, state?
Thank you, Your Honor. Mr. Nieves, what do you do for a living?
I'm a digital forensic examiner for the Federal Bureau of Investigation.
And how long have you been doing that?
I've been forensic examiner for 18 years now.
Okay. And what is your training?
I have a bachelor's degree from Florida International University in Management Information Systems. I also have a master's degree from Florida International University as well in Management Information Systems. I'm certified by the FBI to do forensics on Windows machines, Macintosh machines, cell phones, Linux and Unix systems. I also have certifications that are from the SANS Institute, which is like an independent organization that does cybersecurity training. So some of the certifications I hold from them are the GX Certified Forensic Analyst, GX Certified Forensic Examiner, Advanced Smartphone Forensics, as well as incident handling.
Okay. And you indicated that your title is Senior Forensic Examiner?
That's correct, sir.
Okay. And do you handle digital forensics?
Yes, sir.
What is digital forensics?
Digital forensics involves collecting, preserving, and analyzing and extracting digital evidence, meaning anything that could come from a digital device. It could be a laptop, it could be a server, it could be a desktop computer, a cell phone, an external hard drive, a thumb drive, cameras. So anything that stores information in a digital format, we're tasked with analyzing those sort of items and extracting data in order to assist with the cases.
Okay. And the process that you just described, how many times have you done that in your career?
I've done probably over 1,000 examinations.
Okay. Mr. Navis, I'd like to call your attention to Friday, February the 16th, 2018. Did you have an occasion to respond to a certain location?
Yes.
And where did you respond to?
I was asked to respond to Marjorie Stoneman Douglas in reference to providing assistance with a search warrant to collect the video surveillance system from the high school.
Okay. And who were you with?
I was with Special Agent Carlos Costello.
Okay. Mr. Navis, I'd like to show you State's exhibits number 17, 16, and number 15, sir, and ask you if you can identify that.
Yes, these are pictures of the server that was collected on that date.
Okay, and when you collected the server, Mr. Navis, what did you do?
I was assisted by Mr. Kessler, and one of the things that we did before seizing the server was changing the passwords on the server so that we would be able to access the system in an easier fashion after we would have seized it. And he escorted us to the library, and within the library they had the data center. And within the data center there was a cage that had all the different servers. So he identified the server that it was. We changed the passwords as we needed to, removed it from the cage, and then they gave us a cart, and we did the necessary paperwork for chain of custody purposes, and then we rolled it out.
Okay. And what did you, when's the next time you saw the server? Did you take the server somewhere?
So that night I took the server back to the Miami field office of the FBI, and on Monday morning was when I started working on the server once again.
Okay.
As far as starting the extraction for what had been requested.
Okay. And let me show you now State's Exhibit marked T for identification, and ask you, Mr. Davis, if you can identify this.
This is the solid storage drive that contains the video that was extracted from the Parkland server.
Okay, and how, the server contained a lot of information, right?
Yes.
Okay, a lot of hours?
Yes.
Did you narrow it down when you extracted it to get this exhibit?
Correct. This exhibit contains 6 hours on the date of the incident on February 14th, 2018. And it runs from 1 p.m. until 7 p.m.
Okay, and did you hand this exhibit to someone?
Yes.
Who did you hand it to?
His name was Ron from Broward Sheriff's Office.
Ron Lowther, is that familiar?
Yes, sir. That's correct.
Did you also make another video just like that you sent to Vigilon, to Dan Booth?
Yes.
Do you know who Vigilon is?
Vigilon is the manufacturer of the surveillance system that was installed at Marjorie Stoneman Douglas.
Okay. And did you initial that exhibit in front of you?
Yes, I did.
It's exhibit, I'm sorry. Memory's bad. Exhibit T?
Yes, sir.
Okay. And the hard drive that you sent to Vigilon Dan Booth, did you initial that also?
Yes, I did.
Okay. Your Honor, I'd like to offer now State's Exhibit T.
Okay, States T for identification will be received as States 18, 1-8.
Thank you. Your Honor, I have no other witnesses today.
Okay.
Dan Booth from the Vigilon won't be in town until tonight.
Okay.
Would it be all right with defense and the court, instead of bringing Mr. Neves back to identify his initials in that hard drive, we can agree he signed that?
I don't have a problem with that, Judge.
Okay.
Okay.
Okay. All right, if there's any problem, Mr. Neves, I'll call you, but thank you. Thank you.
Thank you, Mr. Sands.
No questions.
Mr. Wheeler, do you have any questions?
No
Do you have any questions?
No questions.
Okay, thank you, sir. You're excused.
Thank you, ma'am.
Okay, ladies and gentlemen of the jury, so I told you our goal would be 5, sometimes a little earlier, once in a while maybe a little later, but today we're ending around 4:30, so that's good. We're on schedule. I'm not keeping you late like I did a few times, and I apologize again for that. So for tonight, please leave your belongings, not your belongings, but your notepads behind. Please remember, and you're going to be able to probably repeat this verbatim at the end of the trial, because I'm going to tell you so many times, but remember, you may not have any discussion of any sort with friends or family members about the case or the people and places involved, and this includes even your closest family members. They may ask questions of you or make comments to you. You may not discuss what goes on in here in the courtroom with anyone whatsoever, even your spouse, your grandmother, your anybody. You cannot discuss what goes on in here, and this order remains in effect until I excuse you at the end of the trial. So please remember that. Also remember that if for some reason someone were to approach you about this case, whether it be someone you know or otherwise, tell them you cannot discuss it and report it immediately to me. Okay, for tonight, have a safe drive. The sheriff's office is going to see you to your parking area, and for tomorrow we're going to follow the same procedure where I'm going to ask you to please be here at the same time, 8:30. It takes a while. I know you all are having to go through 2 screening processes. I apologize for that, but we're trying to accommodate you and make it as quick and efficient as possible. So we'll follow the same procedure for tomorrow. I do know that some of you had asked when we were calling, making the reminder phone calls about your jury service, some of you had asked if you could bring snacks, and that's absolutely fine. You have that jury room back there, and if you want to bring snacks, coffee, anything that you want to bring, that's fine, so that when you're on a break, you can utilize your whatever you brought from home. Is there any questions about the procedure or parking or times or anything to that effect? Okay, you all are excused. Thank you very much, and I'll see you tomorrow. Okay, the jurors are excused. We are in recess for the day. We are going to start tomorrow at 9 o'clock. You all have the schedule that I'm trying to stick to as far as when everyone can enter the courtroom and when the jurors are brought up and so on and so forth. And other than that, I'll see you all tomorrow.